Could I please request Suruchi Suri, Working Secretary of the UIA, to welcome Justice Joshi with a bouquet of flowers and a potted plant. Thank you. Mr. Venugopal, please.
Honorable Mr. Justice Arvind Kumar, Judge, Supreme Court of India. Honorable Mr. C.M. Joshi, former Judge of Karnataka High Court. Honorable Judges of the Karnataka High Court and of the Delhi High Court, present and past. It is my privilege and honor today to welcome Justice Arvind Kumar and Justice Joshi to this session, which is the plenary session on artificial intelligence prevention and resolution of disputes. I had first met, I hope Justice Arvind Kumar will not mind my saying that I had first met him in the late 2000s when I used to come to Karnataka, and he was the Assistant Solicitor General for India at that time. Since then, of course, he has had a very distinguished career, first in the Karnataka High Court, then in the Gujarat High Court as Chief Justice of Gujarat, and finally on his elevation to the Supreme Court of India. Justice Arvind Kumar has had a very illustrious career as a judge, displaying a strong concern for justice delivery, not merely in the ordinary way, but also to the masses. That distinguishes him, I think, from many other judges. In his role as the head of the Karnataka State Legal Services Authority, and then again subsequently in the Gujarat High Court as Chief Justice, he has pioneered a number of interesting innovations. I myself learned of this only recently, but he started something called Signal Schools in Gujarat, where he encouraged the delivery of knowledge to street children, etc., at traffic signals using buses, Gujarat Roadways buses. That is buses that had been, that were no longer being used. And in those buses, street children and others were taught about justice delivery. That, I think, is a very interesting idea, because most people in this country have a very vague notion of how courts work and how the justice delivery system functions. Also, displaying a deep concern for increasing the pace at which the courts function, he introduced a system of justice clocks which were put in every courtroom so that judges were constantly aware of how many cases are pending and how many cases are disposed. That again is something that is extremely important for the justice delivery system in India, given the huge pendency of cases. And then he has also displayed great concern for human rights, embodied in the fundamental rights. During the COVID period, he was part of the bench that delivered far-reaching orders designed to ensure that the poor got not only help in the form of medicines, etc., but also that they had livelihoods. I don't know if I'm being controversial here, but more recently in the Supreme Court, one would recall how he asked many probing questions of the government in the Sonam Wangchuk case. And while I'm not clear whether that is the cause, the government did rethink and decide to release Sonam Wangchuk from preventive detention. These are all examples of how a thinking judge with a deep concern for fundamental rights and human rights can make a huge change in society. I have no doubt that we will have a great deal more to look forward to in what has been a very distinguished career so far in the Supreme Court. I would also like to welcome Justice C.M. Joshi, who is a much loved figure, I am told, in the Karnataka bar as well as in the Karnataka judiciary. He was both a very distinguished district judge and then a Karnataka High Court judge. and he has some strong views on artificial intelligence, so we can look forward with great interest to the talks, the address that Justice Arvind Kumar and then Justice Joshi will give us. I would request Justice Arvind Kumar now to address us. I would request Justice C.N. Joshi to address us.
Reverend Honorable Justice Arvind Kumar, Judge, Supreme Court of India, Mr. Krishnan Venugopal, all other office bearers and officials of the UIA, distinguished judges of Karnataka High Court and Delhi High Court, present and former, dear colleagues, students of law and my friends. I think we have crossed the time which was earmarked for this plenary session, so I'll be short, bullet points. See, it is my privilege to stand before this August gathering on artificial intelligence and the future of dispute prevention and resolution. We meet at a turning point. AI is no longer a distant promise. It is here. It is very much here, reshaping the commerce, governance, justice, and it comes both the opportunity and the responsibility. How we have to use it, absorb it, reshape our professions. So to begin with, I'll just go through the bullet points so that I can save the time, and you are all eager to hear. Justice Arvind Kumar was the pioneer on this aspect. And in the other sessions, we are yet to hear the experts, Professor Das of IIITB Bangalore, and many others. It is said that the best dispute is the one that never arises. That never arises, whether it can be resolved at that stage itself. And that is the pre-litigation techniques which are being used in mediation. Commercial disputes are bound to go for a mediation so that it doesn't come to the court. Similarly, the best dispute is the one that never arises. At the heart of our discussions lies a simple truth: prevention is better than cure. AI gives us the foresight, predictive analytics that warn of risks of the litigation, contract analysis that removes the ambiguity, compliance monitoring that ensures the clarity. If these can be provided by AI, why can't it be preventive one? If we embed these tools wisely, we can reduce the conflict before it ever reaches the courtroom. That is the promise of prevention. The second aspect, AI in the digital trade and reforms, which we are going to delve in detail. Digital trade is the lifeblood of our global economy. Whether you want it or not, it is there, it will be there. AI strengthens trust, detecting fraud, ensuring transparency, harmonizing the standards across borders. But there is a challenge. Innovation must walk hand in hand with regulation. whether that is being done or not, and we are at the crossroads. Efficiency must never outrun the fairness. This conference is our chance to explore the same. The third point which we may have to think is the data privacy and security. It is well known that AI thrives on data. Without data, AI is not there. Yet, data is the most sensitive currency of our age. Data is the present day oil. Hope President Trump is not hearing us. Privacy, security, and ethical use of the data are non-negotiable. At any cost, no, they are not negotiable. We must confront bias, misuse, and surveillance. We must build frameworks that protect the individuals and uphold the trust. If the data we have, either in the form of the case records or pleadings or whatever it is, we fed into the system, and then whether it is protected and whether the people have the trust in us. So the trust is a basis. The guardrails must be strong, whether the AI platforms are free to distribute the data, what will be the repercussions? The DPDP Act is there, the rules are there. A company, if it divulges the data without the consent, without the consent of the data parent, 250 crores. If the company is worth 100 crores, gone, shut it down. The repercussions are huge. Repercussions are huge. The DPDP Act provides some guardrails and puts barrier on data that can be shared. AI must be in conformity with the regulatory framework. These are some of the guardrails which we have to build. I don't know whether the present AI systems are building it or not. Without trust, AI cannot serve justice. It cannot be used. Otherwise, we will be, I don't know whether we will be in compliance with the DPDP Act or not. Fourth aspect, contracts, chatbots, and negotiation assistance. Contracts are architecture of the commerce. There cannot be any doubt on that. AI-driven drafting tools, negotiation assistants, and chatbots promise clarity, speed, and accessibility. They democratize the legal knowledge, but they also raise profound questions. And can the machines mediate human intent? How do we ensure neutrality? There is no bias in automated negotiations? Chatbots, can they do it? Can AI cater to the doctrines of the contract, like force majeure or doctrine of frustration? Can they do it? Or whether we have to think, we may have to reinvent these doctrines. Privity of contract, privity of consideration, promissory estoppel, doctrine of restitution, doctrine of frustration. These are all the doctrines which are there. Whether the AI can delve into that, deal into that, or whether we have to think of something else, something other doctrines which we have to evolve. These have been evolved by the mankind. AI is there is such a great shift which is going to happen. Fifth point, AI and other technologies for resolution. Beyond the prevention lies the resolution of the disputes and conflicts. Blockchain for secure evidence, smart contracts for automatic enforcement, AI for case triage. These are the three aspects. Together they offer speed, transparency, efficiency. But efficiency must never come at the cost of justice. Howsoever efficient may be, no, at the cost of justice, not at the cost of justice. That should be the bottom line. Our task is to integrate a technology without losing the sight of the human values. The sixth aspect which I would like to emphasize is AI and the judiciary. Finally, the judiciary itself. AI can assist the judge managing the cases, analyzing the precedents, reviewing the documents. It can reduce delays, enhance consistency. Yes, but let us be clear. As of now, AI is an assistant. AI is not the master, not a substitute. It cannot substitute judicial wisdom, human empathy, moral reasoning. These cannot be automated. Whether the demeanor of a witness in a case which was seen by the trial judge can be seen by the AI to write judgment or suggest? No. And therefore, AI is an assistant, not a replacement. But let us be clear on this aspect. The role of the judge remains irreplaceable. AI must empower, not replace. A slight deviation on this aspect. What we say is justice is justice, equity and good conscience. Whether these can be embedded in an AI tool? As of now, I do not know. It can only interpret the things which you have fed into that, that's all. Nothing else. Where is the empathy? It is not there. It can only suggest. If litigants go to AI tool and then find out what is the chance of their success on the basis of the available facts, yes, it can assist them in negotiating a settlement. But when it comes to the court, AI cannot replace a judge. AI cannot replace a lawyer also. Seventh aspect, I would like to place on record some observations made about 10 years back. I think you have all heard Richard Susskind, who wrote a book on about the future of professions. Richard Susskind, in his Future of Professions, reminds us that technology will not simply support professionals, it will transform them. He argues that the expertise, once locked in institutions, will be increasingly delivered through systems, platforms, and AI. Knowledge will move from being scarce and expensive to being abundant and accessible. For the legal profession, what is the effect of it? This means a profound shift from bespoke human service to technology-enabled solutions. Client need not come to the lawyer. From disputes resolved in courtrooms to disputes prevented by intelligent systems. From justice delayed to justice delivered. Swiftly, transparently, and fairly. The question is not whether this transformation will happen, but how will we shape it? We have to shape it. AI is there. Whether you want or not, it is there. But whether we will be shaping it in a fashion that is in conformity with the justice, equity and good conscience. Whether it can be used for resolution of the disputes or prevention of the disputes. This is the hallmark which we have to endure, goals which we have to endure. As we embark on this conference, let us see how AI is not merely a tool of efficiency, but as an instrument of fairness, trust, and human dignity. Fairness, again, encompasses accountability. Whether an AI tool, which is being available now, ChatGPT, various other things are there, Perplexities, Llama, all those things, generative AI tools, whether they are far from bias, we don't know. We only know that AI works on patterns, huge data, that if the data is incorrect or biased, then obviously the result may also be biased. This is what is available in the public domain. So if something is not there in the public domain, how a litigant would appreciate that? The famous case of Loomis in USA is an example how that was challenged, that the system the court used for punishment was not transparent, but it was opaque, and as a result, it was susceptible for a challenge. Of course, court held that it was only a suggestive, and therefore the appeal was not sustainable. But however, if opacity is there, then how will the people trust it? So that is the bottom line. These are the challenges which we have, and this is the occasion when we have to deal with that. Let us shape the AI not just as a tool of efficiency, but as an instrument of fairness, trust, and human dignity. That is the goal which we have to look at, not merely a tool of efficiency. With this, I think I come to an end, and I look forward for the deliberations throughout the day on these aspects. Thank you.
May I request Justice Arvind Kumar to deliver the plenary address?
Justice C.M. Joshi, former Judge, Karnataka High Court, Mr. Krishnan Venugopal, Senior Advocate and National Representative for UIA in India, the organizing committee members, whom I know, Jai Kumar Patil, Shreyas Jaisima, and of course, the President of UIA India Chapter, Mr. A.K. Ganguly, Learned Senior Advocate, my esteemed brother and sister judges, learned judicial officers, and all the participants. It is indeed a great pleasure to be present and addressing this august gathering. I extend my greetings to the organizers and especially to Mamta Tiwari, who has taken a lot of pains in organizing this wonderful event. It is my privilege that I can address a global phenomenon which has slowly seeped into legal infrastructure, that is artificial intelligence. Initially, when I saw the topic for the first time, I was taken back to the time of my practice years, where we used to go to libraries for searching the citations, digests, notes. Time has advanced that we had legal research engines operating on the internet. Then we used the keywords to look for case laws. But now we have artificial intelligence, representing itself as the one-stop solution for everything. This drastic dependence on AI is due to the immense pressure on the legal ecosystem, which has now reached a pendency of 5 crores. in the country, and while we are looking for something to ultimately try to ease the burden of this judicial workload, AA has walked in to fill those gaps, forcing us to now shed the old regime of traditional methods and embrace digital innovations. On various occasions and in various platforms, many brother and sister judges have highlighted the concerns of AA, but AI is always surprising us. In the legal ecosystem of India, AA has been nothing short of bittersweet experience. As I recall, we have addressed the implication of AI on all platforms, and most recently in the AI Summit, which attracted the global attention. But with the use of AI in judicial process, especially in India, several questions arise, and to answer the same, we have gathered here to deliberate upon the pros and cons. It calls upon us to not simply think about tools, but also about systems. Not simply about efficiency, but about legitimacy. Not simply about innovation, but about institutional design. The use of AI across the globe has been present. Much has already been said in various forums about the use of AI by USA, but I specifically want to highlight or point a few instances which particularly stand out. First, at Brazil, which was facing the same problem as we are facing today about the pendency of cases. So it developed a AI named Victor. Victor has the ability to classify the papers and divide them into independent PDFs. A work that was traditionally being done in 1 hour is now done in 5 seconds. Socrates is another such tool. It analyzes new cases, categorizes them based on similarity. The function is to collect, analyze, and explore. I want to highlight what Canada has done with its Civil Resolution Tribunal. This is an online tribunal that helps a party understand the pathway leading to his matter. It helps him to learn about the dispute through an AI tool by name Solution Explorer, which asks you certain questions based on which it will help you resolve your dispute on your own. Next is the United Kingdom. What they have used is a tool known as HART, that is Harm Assessment Risk Tool, which segregates the offenders into high risk, moderate risk, and low risk by using 34 predictors, for instance, criminal history, behavior, etc. Argentina is using a AI software, AI called as Prometea. This AI tool identifies patterns and generates predictions based on the data that is already available. If it finds a match, it proposes a solution by drawing analogies. It has an interesting interface as it allows you to talk, chat, and it predicted court rulings in less than 20 seconds with an accuracy rate of 96.28%. Of course, India has not scaled the use of AI as of now. We are still at the nascent stage, and thus we have certain AI tools which help us in administration purposes. As already told, the Supreme Court is using SUPACE, SUVAS, and recently the Kerala High Court has now become the first state in India to introduce a policy regarding use of artificial intelligence tools in district judiciary. This policy is highly regulated and also states that violations may result in disciplinary action. It also goes a step further and warns that AI must never be used indiscriminately and has to be used only for assistance purposes. As Mr. Joshi put it, it is assisted intelligence rather than artificial intelligence. We stand at a significant moment in the life of the legal profession. Every profession periodically encounters a technological shift that compels it to re-examine its assumptions, its methods, and sometimes even its self-image. The law is now in such a moment. For a very long time, legal work was seen as a resistance to automation because it involved reasoning, judgment, interpretation, discretion, and human nuance. That remains true even today. Technology has now become capable of entering those spaces with a degree of scale and speed that earlier generations could not have even imagined. Therefore, we must think carefully about what this moment requires from us. It requires seriousness, but the subject is real. It requires humility, because no one yet fully understands the end state. It requires openness, because resistance to all change is not wisdom. And it requires caution, because not every gain in speed is a gain in justice. To my mind, the theme before us has two distinct but connected dimensions. The first concerns the prevention of disputes. How intelligent our systems may reduce avoidable conflict before it matures into legal contest. The second, the resolution of disputes. How much system may assist courts, tribunals, or other forums once such disputes would arise? If we examine the subject only from the point of view of disposal after conflict, we will have understood only half of it. The more sophisticated vision is one that asks, can intelligence in systems reduce friction before adversarial machinery is set into motion? And when that machinery is set into motion, can intelligent assistance make it more accessible, more efficient, and more just? In other words, by the time a dispute arrives before a judge, an arbitrator, or a tribunal, it is often the end product of many failures that occurred much earlier. If artificial intelligence is to be taken seriously in this field, it must be seen not only as an aid to adjudication, but also an aid to institutional foresight. Consider these possibilities during your deliberations. AI may help detect inconsistencies in contractual documents before they generate competing claims. It may flag anomalies in compliance patterns before they attract sanctions or liability. It may identify procedural irregularities before orders are passed, thereby reducing future challenges. It may improve internal document discipline, reduce ambiguity, track deadlines, surface patterns of recurring grievance, and assist public and private institutions in recognizing the source from which avoidable disputes repeatedly emerge. A system that learns where disputes usually come from is a system that may, if properly used, reduce the number of disputes that ever ripen into litigation. This is no small gain. In that sense, AI may help restore something law often neglects: the importance of anticipation. A justice system that only reacts after conflict has hardened is always under strain. A justice system supported by intelligent prevention mechanism may reduce that strain at source. This is the first promise of this technology. Then comes the resolution of disputes. Here, the potential applications are obvious and substantial. There are cases in which records run into thousands of pages. There are matters in which factual chronology is dispersed across multiple proceedings over many years. There are commercial disputes involving layered contracts. There are criminal prosecutions involving digital trials, device records, audit logs, and electronic evidence. There are constitutional matters where legal issues overlap with statutory, administrative, and factual complexity. In all these situations, the burden on institution is not merely interpretative, it is organizational. Here, AI can assist meaningfully. Number one, it can help in transcription. Two, in translation across Indian languages. It can improve searchability of large records, cluster issues arising from pleadings, assist in document review, can build chronologies, it can compare versions, it can support case management, it can help institutions identify patterns of adjournment, delay, or procedural bottlenecks. It can reduce the time spent on purely mechanical labor and allow greater focus on substantive preparation. There are not glamorous interventions, but they are deeply important. Legal systems are often improved not by spectacle, but by removing friction. A court with stable, usable records functions better. A lawyer with searchable material prepares better. A tribunal with efficient workflow hears the matter better. A litigant who can access and understand the process participates in a better manner. These are the real gains, and they should not be dismissed merely because the subject is new. At the same time, we must keep our balance. Technology can assist the administration of justice. It cannot be allowed to alter the moral structure of justice. It is important, therefore, to say plainly that law is not merely an information problem, it is a judgment problem. Artificial intelligence may organize material, it cannot substitute conscience. It may retrieve patterns, it cannot fully appreciate the context. It may identify similarity, it cannot by that fact alone determine justice. It may process precedent, it cannot bear the constitutional responsibility of deciding between competing rights, obligations, interests, and consequences. The adjudicatory function still remains at its core, that is, human intervention. A judge does not merely select from data. A judge listens, evaluates, reasons, distinguishes, balances, and then decides. A judge functions within a discipline of accountability. A reasoned order is not an incidental output, it is a part of moral grammar of law. The distinction must remain firm, because if we lose it, then efficiency will begin to masquerade as justice, and this would be a serious institutional mistake. A justice system may value efficiency, it may not worship it. Speed matters, certainly. Delay harms rights, increases costs, and undermines public confidence. But a justice system that becomes so impatient for faster outcomes that it compromises hearing, transparency, explanation, and responsibility will discover that what it has accelerated is not justice but only disposal. That is why the real question is not whether AI is good or bad. That formulation is too crude. The real question is whether AI can be integrated into legal institutions in a manner that preserves fairness, accountability, human oversight, access, and the duty to reason. Having said so, I would like to congratulate the organizers for having chosen Bengaluru as the place, because it is called the Silicon City of India. And I say this with additional preface that Delhi is not India, India is not Delhi. And that brings me to a point which in my view must be stated clearly without any hesitation. For too long, Indian legal culture has indulged in a misplaced glorification of Delhi. Because it is the capital, because the Supreme Court sits there, because certain categories of high value and high visibility litigation pass through, an impression has been cultivated that Delhi is the natural pinnacle of legal ability in India. That impression is utterly false. It is institutionally produced, it is commercially amplified, it is socially repeated, but false nonetheless. Delhi is equally important, but Delhi is not India and India is not Delhi. This is not a slogan, it is only a corrective measure. A hierarchy of forums does not create a hierarchy of minds. The fact that certain disputes culminate in Delhi does not mean that legal excellence begins there. The fact that final court practice, national tribunals, and high-value sectors may be concentrated there does not justify the idea that one metropolitan circuit constitutes a superior legal class and that the rest of the country must merely follow. The attitude must go. There is no constitutional caste system among bars. There is no doctrine by which an advocate acquires greater intrinsic worth by proximity to the capital. There is no warrant for treating one metropolitan legal culture as be-all and end-all of Indian dispute resolution. Much of what is often projected as superiority is, in truth, a byproduct of litigation hierarchy. Institutional concentration, visibility, and pricing power, it should not be mistaken for a monopoly of merit. Indian law is not manufactured in Delhi and distributed to the rest of the republic. It is argued, shaped, tested, refined, deepened across India, across high courts, district courts, tribunals, commercial courts, arbitral institutions, and bars of great ability that may not always enjoy the same visibility, but are no less serious, no less rigorous, and no less vital to the legal life of this country. The Indian legal system draws its intelligence from the whole republic, not from one city alone. This point becomes even more important in the age of AI, because if legal AI tools are built around Delhi-centric data sets, Delhi-centric assumptions, Delhi-centric visibility, and Delhi-centric notions of what counts as important lawyering, then technology will not democratize the profession. It will only merely automate an old distortion. It will hard code metropolitan hierarchy into the future. This must not happen. A model trained on a narrow data set overfits. A legal future trained on the habits of assumptions of one city will do exactly the same. It will not serve India. It will only reproduce a capital-centric imagination and mistake it for national reality. This is not acceptable in a constitutional republic as diverse, federal, and multilingual and institutionally distributed as ours. The question would be why Bangalore must lead. And that is what precisely why Bangalore must be at the forefront. Bangalore is not merely the venue for this conversation, it is one of the natural places from which this conversation must proceed. Here I may state that when even the whole world was thinking of science, way back in 1908, Nalvadi Krishnaraj Wadiyar, who was one of the ruler of the Mysore state, he wanted one of the best laboratory of the world to be established in India. So it is at that stage, if you may all recall, when Swami Vivekananda was proceeding to Chicago, he met Tata on the ship he was traveling. And when he had interaction with Tata, he said, I am going to France and London to ascertain as to whether the sand found in some parts of the country contains iron or not. So Mr. Vivekananda, Swami Vivekananda said, do you think even if it is found, will they be answering in favor of India? No one wants India to be rich or scientifically developed. So the answer will be no. So when Tata asked what should be done, he said, you are having money. When Swami Vivekananda said, you are having money, establish your own scientific institution. And it is at that stage, he said, look here, I was sponsored by the Mysore Maharaja to go to America. So why don't you go and approach the Mysore Maharaja? He approached, and the ruler of Mysore, Mr. Nalvadi Krishnaraj Wadiyar, sanctioned 361 acres of land, now which is in the heart of the city. Now it is called, earlier it was Tata Institute, now it is Indian Institute of Science. That is India. And we should be proud of that. This is where the technology started. The first city in the country, whole country, where electricity came was in Bangalore. So it is India's technology capital. It is a city where engineering system design, innovation, product thinking, digital infrastructure, data culture, and entrepreneurship are not abstraction but lived realities. No doubt we agree that most of the scientists who work here may not be flashy. If artificial intelligence is to be meaningfully integrated into legal workplaces, court systems, professional training, dispute management architecture, legal services, and institutional workflow, then Bengaluru ought to lead that transformation. Not symbolically, not ceremonially, but substantially. If India is serious about smarter case management, multilingual interfaces, usable digital records, practical research tools, workflow intelligence in chambers, document analytics, and technology that genuinely assists courts and lawyers, then Bengaluru is one of the principal ecosystems from which such tools should and will emerge. I put the matter more strongly. India should not be a passive consumer of legal technology developed elsewhere in forums unsuited to our institutional needs. India must shape the legal technologies it adopts, and Bangalore gives us the ecosystem to do that intellectually, technologically, and practically. This city can help build legal tools that are not merely efficient but Indian in design, not merely sophisticated but accessible, not merely impressive in demonstration but usable in real institutional settings. That is why Bangalore matters to this conversation in a substantive way. democratization of legal profession through AI. But there is a further reason why this moment matters. AI holds the possibility of democratizing the legal profession. A profession becomes stronger when knowledge is democratized, not hoarded. A legal system becomes healthier when competence is widened, not gate-kept. If AI is used wisely, it can help dismantle inherited monopolies over information, technique, and visibility. It can widen the field, it can reduce the unearned advantage that can merely from geographic embedding in a narrow circuit of accumulated access. It can enable a talented lawyer in Bangalore, Hubli, Chennai, Kochi, Jaipur, Guwahati, Indore, Patna, or Ranchi to compete with greater confidence in areas once treated as though they belong to only a few professional centers. This is not a small development. It goes to the structure of opportunity within the profession. And let us be candid. If AI can help break the practical monopoly of certain metropolitan circuits or specialized knowledge, that will be good for the Indian bar. It will make the profession wider, healthier, and more competitive in the best sense. But that promise will not fulfill itself automatically. Technology can widen access, it can also deepen inequality. If the best tools remain expensive, opaque, English dominant, and available only to already powerful institutions, then AI will become merely an elite productivity multiplier. It will make the strong stronger. It will not democratize the field. The future, therefore, must be consciously shaped. The question is whether or not AI will enter the profession. It already has. The question is whether it will be used to widen the participation or merely accelerate the privilege. The same disciplined perspective is necessary when we think of courts and adjudicatory systems. Courts do not need theoretical futurism. They need practical intelligence. They need better records. They need usable transcription. They need multilingual support. They need easier navigation of bulky pleadings. They need systems that reduce avoidable procedural friction. They need tools that make case management more rational without compromising fairness. They need assistance that helps judges and lawyers deal with volume more effectively. These are all practical needs, and if AI can serve them, it can do immense institutional good. But here again, the balance must be preserved. A justice system cannot surrender reason, hearing, accountability, and human supervision in the name of technological sophistication. It must be transparent enough to be trusted. It must be accountable enough to be questioned. It must be accessible enough to reduce inequality, not deepen it. And it must be supervised enough that responsibility remains where the Constitution places it, upon human institution and human decision makers. The promise of AI lies in assistance, not abdication. In conclusion, I would like to state that we are entering a period in which legal authority, legal visibility, and legal access may increasingly be mediated through technology. That makes this a constitutional moment for the profession. We must decide whether AI will reinforce inherited concentration of powers or help distribute capability more widely. We must decide whether the future of dispute prevention and dispute resolution in India will be written through one more metropolitan lens or through the full intelligence of the Republic. We must decide whether technology will merely speed up old hierarchies or help dismantle them. Delhi has its place, it has its institution, it has its significance, but Delhi is not India and India is not Delhi. The future of Indian law cannot be designed as though the experience of one city exhausts the experience of the nation. Bengaluru, as the technology capital of India, must be one of the principal places from which this new legal future is shaped, not at the margins, at the forefront. It can help prevent disputes more intelligently, it can help resolve disputes more efficiently, it can widen access to legal capability, strengthen the courts without displacing the judgment, and it can help ensure that the next generation of legal infrastructure reflects the diversity, federalism, plurality, and depth of the Indian Republic. That is the challenge before us, and I hope and trust the deliberations in this conference would lead positive results which will be very, very useful to the judicial system. Once again, thanking the organizers for having extended me an opportunity to participate in this and give my share of, to share my thoughts. I thank every one of you. Namaskar, Jai Hind, Jai Karnataka.
I would like to thank Justice Arvind Kumar for a scintillating and thought-provoking plenary address, and of course emphasizing the importance of Bangalore in the artificial intelligence debate about how to use it in the law. And I would of course heartily endorse what he has said about the importance of Karnataka in our justice delivery system nationally. It has contributed so many illustrious judges to the Supreme Court of India. I dare say Justice Arvind Kumar is one of them. I would also like to thank Justice C.M. Joshi, who has also given us a very thought-provoking and incisive address on artificial intelligence in the law and the importance of maintaining human oversight. Thank you very much, sir.
Although the program said that there would be a coffee break now, but I think we are really lagging behind schedule. So I'll request everyone to please be seated. We'll straight away go into the technical session, the first technical session of the day. And after that, we'll take the lunch break. Our first technical session of the day is Artificial Intelligence in Digital Trade and Platforms. May I please invite on stage Honorable Mr. Justice Harish Vaidyanathan Shankar. He is Judge, Delhi High Court. He is the co-chair, and as the chair was Honorable Ms. Justice Anu Shivraman, but she had to leave. So I would request Justice Vaidyanathan to please chair the session also. And although we do have a small video clip from Justice Anu Shivraman, and we'll play it for a while. Could I also invite the speakers of the dais? The speakers for the session are Professor Debarata Das, Director, International Institute of Information Technology; Mr. Parag Tripathi, Senior Advocate, Supreme Court of India; Mr. Prakash Narayanan, General Counsel, L&T Infotech; and Mr. Gunjan Sharma, Partner, Volterra Fietta, London. Could Justice Shivraman's video clip be played, please? Thank you.
A very good afternoon to one and all. The co-chair of this session, Justice Harish Vaidyanathan Shankar, Judge, Delhi High Court. The speakers of the session, Professor Debabrata Das, Director, International Institute of Information Technology, Bengaluru. Mr. Parag Tripathi, Senior Advocate. Mr. Prakash Narayan, Mr. Gunjan Sharma. All participants of today's conference, ladies and gentlemen. The speakers of today's session bring immense practical experience and knowledge of the topic under discussion. To those of us who were children of the past century, the present strides in AI is the science fiction of our childhood stories. As much as we try to grapple with the advancement happening in today's world, we are at heart still in awe of the immense possibilities and potential problems of artificial intelligence. The topic of discussion today is AI in digital trade and platforms. AI-driven personalization has fundamentally transformed how consumers interact with digital platforms. While this creates convenience and efficiency, it also raises an important question: whether the traditional model of user consent is sufficient to safeguard consumer rights in such an environment. So what is consumer consent? What do we need to know? We need to know what data is being collected, for what purpose, and how it is dealt with. Do we get answers to these crucial questions? The answers are technically there, hidden away in the verbose policy statements provided by the website or the platform before your interaction starts. Does anybody ever read them? You scroll down and click agree without realizing what you are agreeing to. This is called consent fatigue. From a constitutional perspective, this consent fatigue has significant implications because in India, the right to privacy has been recognized as a fundamental right under the K.S. Puttaswamy judgment. This right includes informational self-determination and decisional autonomy, meaning individuals should have genuine control over their personal data. However, when consent is given mechanically due to fatigue, it cannot be considered to be free or informed, thereby undermining these constitutional values. So, how do we regulate the use of digital platforms? Regulatory response in India includes the Digital Personal Data Protection Act 2023, the RBI Digital Lending Directions 2025, Competition Commission Market Study on AI and Competition, and the proposed Digital Competition Bill. How does legislation address these issues? Are the provisions sufficient? What is the way forward? We look forward to hearing more about the problems and solutions from today's experienced speakers, and we also anticipate a summing up and further inputs from the co-chair. I express my deep gratitude to the organizers of this conference for holding a conference which is so relevant and imperative today. Thank you very much.
So sorry, I forgot that I have now to don the hat of the chair of the session. So I was actually hoping that Justice Shivraman, if she's there, she would conduct the proceedings, and she would probably have done a much better job. But nonetheless, since I am but a poor substitute, I would start with requesting Professor Das to commence with what I'm sure would be a very insightful conversation and a presentation, since he is, after all, an eminent person from the field itself. Professor Das, if I may request you, please.
So I will stand because you can watch from here also. Thank you. So thank you, Justice Harish, and all the honorable judges and dignitaries, and And can I get the slide changer, please? Then in the meantime, when they're bringing me the slide changer, I will, the students, if they're there, I heard they're there. So can I ask you a question? Because I'm a professor, it's my habit of asking questions. So quickly answers, because only 10 to 15 minutes given to me. So it's a very interesting question. And when a critical AI-based application deployed or started implemented, can you tell me the name? And almost every one of us has used it. But, and second clue is that it is like a equal to, if it starts malfunctioning, it is life and death. Every one of us use it. Or it is a part of it. ChatGPT, okay. Google, Gemini AI, Google Map, very interesting. So not, Google Map is not life and death. I gave you the second clue, very close. Okay. So I will give you because due to the time constraints, I am not going to ask you very interesting. He also goes through it, I also goes through it, every one of us goes through it. Traffic signal? WhatsApp? Very interesting answers. And can you guess which year it happened? That is a very tough question. Second one, which I now ask, which year? And it is critical, and everyone else goes through it. It is exactly 100 years ago. 110 years ago, not 100 years. 110 years ago, 1916, autopilot, which is used in the aeroplane, got the patent by Mr. Sperry, S-P-R-R-Y, because 1903 aeroplane was invented, Wright brothers. They flew for a few seconds. There was a gentleman standing there. He saw the pilot is looking at a lot of parameters to be, at that time, very initial stage. 1912, 1912, he filed the patent. 1916, he got the patent, which is called gyroscope automations. Then autopiloting, a lot of research happened. And 1933 onwards, it is got deployed in the plane. And in fact, many of us don't talk about that because it is not so much talked, because it is only pilot knows and some engineers know. So we not affect the common man, but only we sit inside. And after the takeoff, after few minutes, 1-2 minutes, we are completely in autopilot till the destination. If it malfunctions, it is life and death. Sorry to say that, but this is the truth. So now it computes thousands of parameters and takes the plane to the destination without any problem. Even in turbulence, it takes complete charge. Pilot cannot do so much of calculation so fast to take decisions. So after 25 seconds, till that time, pilot sits quiet, even the turbulence. After 25 to 30 seconds, pilot, due to his domain knowledge, looks at the parameters and divert the plane to different direction or height and all, that's all. So please try to understand that in critical application, AI kind of things are there. Now, because of the computation has come in, can you go to the next, please? So computation have come in, so now these are the things are now in front of us. This is the 4th round of try by the AI into the mankind. And so I come from IIIT Bangalore, as already we introduced. Next slides. I don't want. So look at this. This is an institute which you will feel proud as an Indian, is that we silently developed 4 products in the campus. One is called MOSIP, Modular Open Source Identity Platform, CDPI, OpenGTP, COS, everywhere AI we use, AI used in some of these projects. And you'll be very happy as an Indian is that these 4 products are rolling out in 45 countries and 1.3 billion citizens, including India. We are impacting their day-to-day life from better to better. One of the latest one is, which is come out in this AI summit in Delhi, is this Mahavistara, which is for the farmers for the Maharashtra. Within 1 month, 15 lakhs farmers register, and their livelihood has become better because of the local language got integrated. So and you can see the list of countries here. The countries' numbers are here. So you can come to our campus, I'll show you. With all humbleness, I wanted to say that in digital public infrastructure, which is very critical for any country, we are now, by the external agencies, told us that we are the #1 university in the world which is serving the various countries and the citizens. So next slide. Thank you. So now, thank you. So now coming to the point, technical, I'll be only talking technical. So already before me, Justice Joshi, Justice Arvind Kumar, and CJI of India, and all those people talked about various legal aspects. But some of the technical aspects, which one thing has not touched, is the privacy. A lot of things has been taught. But one major issue is that is called security. So which I'll be touching on this and quickly. So if you look at the past, was every action required conscious human intent, but not anymore. And the next decade is AI agents and pursue the goal autonomously using tools, making macro and micro decisions. You can't imagine. I'll give you the clues. The startup, 4 days back, there was a startup in Bengaluru. Is the best place because all the startups, the city of this country, and also the #3 in the world, so Bangalore. So these young minds, 20 years, 20 to 24 in between, these minds come up with an ideas of this AI. A company will be registered by a AI tool. There is no human being. And the company will run by the AI. And all the workers will be AI agents. Please be careful. Agentic AI. And they will be doing deal by this agentic AI or the other companies. So there is no human being. What law will catch them? Who is responsible for that? So when I hear to them, this kind of young minds, though they are already 20, 30 years ahead what we are thinking now. So the making a decision, execution, transactions, and navigating yourself on behalf. So India's choice is define our own rules, inherit the framework from elsewhere or other countries. So that is the point which others have said. Next slide, please. So in this slide, I'm not going to talk to you anything because you know what is artificial intelligence, what is agentic AI. I explained to you. Digital trade is the topic given to this session. So this is the platform, the digital platform I will talk, and the algorithmic governance, these two I'll talk. Digital platform is the multi-site, you can see that matchmakers, that is the platform which makes the matchmaking by using algorithm, so buy and sell. So you can see there is a dynamic things happen. Cost going up, coming down, you buy it when a ticket, you see with a lot of demand goes up, goes down. So a lot of things which Joshi said, is that called the fairness, ethics, a lot of things will come up. Scaling and also infrastructure like ONDC, Amazon, Flipkart. And algorithmic governance, the use of the automated system to set the rules of a platform ensuring compliance with the digital personal data protections and Indian trade fairs and all. So these are all being discussed. So, but all decision making is happening by the algorithmics. But nothing to worry. I will tell you why not to worry. Because, can you go to the next slides, please? Because is that if you look at the AI stock exchange, where the SEBI of India I can talk about, which is in our RBI, Reserve Bank of India, they makes the guardrails. This is the rules. And they give to the stock exchanges that you have to follow the rules. So that the technology people, the engineers and the scientists has to follow that. And they come out, if somebody crosses that rules, automatically checked or being caught. So the AI, you can see that e-commerce and digital platform, AI stock exchange and all. So the making the rules is the extremely important. Only worry I have to tell to the lawyers and everybody is that the last bullet in the major AI risk is that bias, unfair, already talk, uncertainty talk. The last one, the security one, which none of you talked, I know, because day before yesterday, late night, I was listening to a research presentation of the topmost labs of the world. There was a presentation called Trojan Hippocampus. So many of you are using slowly those called email tools, AI tools, to collate all the emails, give you the summary, and be careful that that is not a Trojan has been embedded into it. So you have written to your lawyer, junior lawyer, a mail telling that tomorrow morning I will be doing these arguments and all. he will be sleeping. The moment he sees that some critical words or critical informations, he will just pass on to your opponent without your knowledge. So it will be, so AI tools are very good to use and shrinks your time and all, but you should be very, very careful because they are very, very smart way, the high-tech things. There comes the role of the engineers and scientists, how to invent the solutions where this kind of Trojan, hippocampus and a lot of things should not derail your all kind of business kind of things. Next. This is the slide, most important one as a younger generation, because look at this. You can get all the possible we are education, legal, you can see here legal, okay? And here the legal, and this one is, see, each circle is at 10, this is 20%, 40%, 60%, 80, 100%. You can see legal, theoretically, the blue colors are theoretical. We will be 90%, all those things will be AI over the time. And in the legal, till now, the red color is that how much you have achieved till today. We are only achieved 20%. What you see now, only 20%. And you can see all those things are the computer science and math, business and finance, management, and the construction, agriculture, office admin, sales, personal care. So everything, this is the latest scenario. Theoretical means there are engineers sitting in the top labs and in the universities or the industry. They have done this model, theoretical model. Achievement is this much. Okay, so this one you please keep it in mind that you belongs to which category and where it will go and stop. And, okay, so next slide please. So in this case, I will stop, my 10 minutes are almost getting over, 15, 2-3 minutes. So algorithmic bias, already people have talked about. The last one is that the algorithmic, we as an engineer or the scientist should be extremely careful. You people will be the policy makers and the law department will be the guiding rails. They will create the rails, and after a lot of research, a lot of discussions, that rail should be respected by the engineers and scientists to build that systems, which is very complex, very complicated, because if you work into the LLMs and SLM, if there is like a black box to many of you, because inside how it works with respect to various feeds given to it, and also the algorithms are given to it, and the output result decisions, it is very difficult for anyone, humans, to track and find out. So this has to be explainability, and everything has to be clear and cut, and it has to be guarded. Next slide, please. So in these things, the security is one of the important thing we have to focus on these AI tools. Compliances like anti-money laundering and sanctions, this is being taken care of by nowadays. If you do anything, immediately the banks will alert, or the platforms, the trade platforms will alert that this money is going from here to, and everything is tracked now, and transactions are being alerted. So this part, out of this part, only security part is still a lot of research is going on. If the day the security and privacy is taken care of, the AI tool will come in a bigger way. Next. So these are the design of law in agentic economy, regular use of and power, like focus on high impact flow, tailored regulation, risk levels, stronger duties and powerful platforms are coming up, and equip regulators. The regulators are extremely important, as I say, RBI, SBI, law regulators are there. So, and all those things are coming up, and which one can be used, which one cannot be used, and the sandboxes are being used. Next. So in this research is the last slide, this is mine. This is we as a country, from industry, government, academia, and any organization has to do a lot of research. India lacks a lot of research and innovations compared to many other countries. For that only we are falling prey to the others. Whatever they invent, we use it. Sometimes we got biased by them, like which you have seen in the Google and other kind of platforms are doing for that. They're selling their products and all business. They do billions of dollar business in India. And justice takes AI tools for the legal aid, case predictions, and these are the things already discussed. So security is another thing. I'm again coming back to that, defect detection, identity, because just the Justice Department only give verdict if the things are correct, if it is a fake thing, then our decision in the justice will be wrong. So catching the deep fake things are not easy. Extremely brilliant people are sitting on the other side doing fake things. Next slide, please. So this is the two things I wanted to say at the last slide. Let AI learn the rules of our constitution, not the other way around. AI should not detect us that you change your constitution like this, because democratic things, democratization of the nation, republic things will get destroyed, which Justice said. And last one, this is the thing which I come from, is that as an engineering and scientific community, guardrails, not handbrakes. Don't stop us like a handbrake. If you pull, vehicle stops. Don't stop us. Make a guardrail. Show us the rails that you should be between these two lines. This is beyond this line, it is illegal. Beyond that, it is unethical. Stay, invent, and help the society. To support the innovation business in the right direction, if you don't do that, other countries will go ahead of us. Thank you very much.
Thank you, Professor Das, for the very, we felt transported back to a classroom. So thank you very much. And of course, the emphasis on security, I think, yes, that is something that we all need to really take a look at, because with AI, forming such an important part of almost everything, I don't think anything is really secure, so to say, because even our basic actions of sending a message or accessing our telephone is permitting AI to collate and collect information. Next, I believe, is the turn of our very erudite Mr. Parag Tripathi, Senior Advocate. So I request you to, please.
My chairperson in the dais, Justice Harish Vaidyanathan Shankar, distinguished speakers on the dais, distinguished judges, senior advocates, and friends in this audience. I'm aware that I broadly stand between all of you and lunch, but then that's how the script is written. I will try to minimize your pain. What is AI? We all know that. But do we know that for generating these various AI programs, the AI tools, you need huge brick and mortar structures which can go up to 2 to 6 times a football field size. Now this is American football because the article was in an American journal. 2 to 6 times the total energy needs of the state of California, and fresh water which can feed a whole town. This is one aspect of it. I'm not saying it's bad, but it's an aspect we should remember. It's not that AI just dropped in and I started my chatbot communication. Now, we all are in many ways dependent on and indebted to AI agents. Now take the case of...
It was very interesting to note that Mr. Prakash touched upon a point of there being an interaction between the government and businesses to establish what should be the guardrails that are provided. So I think, yes, I think that's an area which really needs to be looked at, because it's only on the basis of the active dialogue that businesses, firstly amongst themselves, are able to agree upon, reach a consensus on what they believe should be the extent to which regulation should, in any manner be brought into the manner in which AI is being used in the business itself, that the next step can be taken. So it was very interesting. Thank you. Thank you. Now may I request Mr. Gunjan Sharma to kindly take the floor.
So let me start by saying thank you to the organizers for the invitation, to Shreyas at Arno Law for the invitation. I have the unique privilege today, I think, going through the speakers list, of being the only non-Indian advocate on a panel, although I'm of Indian origin. I'm a partner at Volterra Fietta, and I am a New York lawyer by training. So before I begin, if you'll allow me, and I do understand that I'm between us and roti, I'll just say a few words I practice public international law, which means I plead before the International Court of Justice for countries such as Barbados, Kenya, the DRC, and the United Arab Emirates in the past few years. And I handle large disputes, investment treaty or commercial. In India, that means usually, not by any choice, I am hired by clients to sue the Indian government or PSUs in claims of 200 to 300 crore rupees or above. I've had some success. So what I wanted to, and I've also had the opportunity to work closely with the Gulf State on its AI regulations. And just a few months ago, talking about liability, I spoke at the Alan Turing Institute on liability for AI operations of satellites and automated satellite systems, which is a nascent field. So that's just because most of you in the room won't know me. I wanted today to concentrate on a very narrow question, but one which I think is increasingly important. We have heard today many times, including from the Chief Justice, that one of the benefits of artificial intelligence, the generative artificial intelligence models that are publicly available, is that non-lawyers at every level can ask questions about the law without paying a fee and get some kind of answer. Non-lawyers, and you'll see this today, I see it today, the nanny for my children does not speak a word of English. She is Spanish. Her texts to me are perfect English and lay out all of her rights as an employee in bullet points. That is AI. And that is good, or it can be good, although AI is not as good in the law as we are, for now, hopefully. But that creates an interesting question. And it's happening to all of us, all practicing private practitioners. Our clients are speaking to AI models before they speak to us. Our clients are putting in confidential, privileged information into public, often public AI models. I mean, you might have your proprietary confidential ones in your office, but most people don't. And they are generating lists of questions and potential strategies and cases that don't exist and rules of law that never existed, so that they can come to a meeting with their lawyer and have a fruitful discussion. And we should be encouraging that kind of forward diligence. I'm seeing this at every level. I'm seeing this when I represent Gulf countries' Ministry of Foreign Affairs, we get AI questions. When I represent lay persons but are business people, AI questions. When I represent pro bono people, AI questions. There's an issue that arises. When a lay person speaks to an AI model before it speaks to a lawyer, are the questions they put to that AI model privileged? Or does the other side get to see all that confidential questions and all those answers and all that back and forth, all those admissions that your junior colleagues in the in-house department may not understand and may say, what if my boss is committing fraud? Doesn't mean you're committing fraud. But all of those questions, they intend to put later to a lawyer, and they put into an AI model, and the AI models click wrap, that's what we're talking about, right? The click consent says anything you give to us is no longer confidential. What happens to the privilege? There are two decisions in the US and the UK. They're the only ones I found that answer this question, and I think they answer them badly. I don't like criticizing judges, but I do. First is UK v. Secretary of State for Home Department, which is a decision from an upper immigration court in England. And it said that if counsel or a client puts in privileged documents and confidential documents into a third-party, non-confidential, non-proprietary AI model, you lose the privilege. Same decision was made by a judge I have great respect for, Judge Rakoff of the Southern District of New York, just this year in United States v. Hepner, H-E-P-P-N-E-R. And I think that's wrong. I think we need to consider what the purpose technical, formalistic approach to privilege in which we say a client who speaks to an AI model is losing the privilege because the AI model is not a member of the Bar Association or not registered as an advocate, does not look to the fundamental purpose of our privilege. The privilege protects a client's ability to obtain legal advice. And in the same way that if you ask a client to come in with records and a calculation of their damages, I would say that their calculator, the numbers they press on the calculator, is privileged. In the same way, I would say that questions a client asks to an artificial intelligence model, when they have a specific purpose of obtaining legal advice later, should enjoy privilege as well. Of course, you can subject that to the exceptions. The crime fraud exception, the exceptions if they talked about it to their friend on the street. But at the end of the day, we have to preserve, in the world of AI, the fundamental privacy interests between a lawyer and a client talking to each other so that the client can understand the law.
Thank you, Mr. Sharma. In fact, this was a very, very interesting one because you're literally, in a manner of speaking, trying to project AI as perhaps a quasi-lawyer to kind of canvas that there should exist a privilege in terms of whatever other queries that are raised by a user of any AI tool or an interface as such. So I think, yes, it's a very interesting concept, and I mean, on a lighter note with respect to the criticism to judges, I mean, they say that judges are to have very thick skin, so I believe it's perfectly fine. We're all used to it on a daily basis, so that's okay. But thank you very much.
Some judges have thick
No,
skin.
no. And I just wanted to extend a warm welcome to my chief, Justice Upadhyay. Thank you, sir, for gracing the occasion. And of course, all the senior members who are here, Justice D.K. Singh, Justice Bambani, Justice Karia, Justice Suraj, Justice Joshi, and all the other Justice, I'm so sorry, I'm forgetting, Banerjee and Shah, Justice Shah. Thank you so much, sir. So it's, I mean, we don't want to keep you away from lunch, but you'll permit me at least 2 to 3 minutes because, I mean, perhaps what I speak may mitigate your hunger to some extent. So essentially, I mean, there was I mean, I think it's very interesting. I was just going through certain aspects of where all AI is coming in and how it is really, it's become all-encompassing. So, I mean, most of us, when we are trying to take a flight, of course, Professor Das had adverted to taking a flight and the general positioning system and etc. But the new way of pricing a ticket, and it's very interesting how it's being priced. So now, based on the ability of a person to spend, airlines have come up with a way of dynamically determining what is a possible price that you can pay. So imagine, say, Justice Karia can spend, say, much higher than perhaps me or anyone else. He'll get a higher rate than the others. So, of course, he can afford it. That's another part of altogether. So, you know, it's very interesting the way AI is now so all-pervasive. I mean, I'm so sorry, Justice Karia. It is purely based on the Honorable Supreme Court Collegium's decision and what was stated there. So please don't take it otherwise. I mean, it's public knowledge now. So, so of course, certain other people who are laughing here, like Senior Counsel, Mr. Avi Singh, I'm sure he'll also get a much higher price than all of us. So that's one part of it, of course. And another part, which I found to some extent is a bit disconcerting, was the fact that, you know, the predictive model which has been put across by Anthropic says that 90% of legal services can be substituted by AI. I mean, I'm scared. I don't know about all of you, but I'm certainly extremely fearful of what the future then holds. Because if this is the, the legal system as we are talking about, we are after all one part of it, as are all lawyers as well. So if what is being spoken about by Anthropic is extending only to lawyers, I'm not sure whether that's the case. I'm sure to some extent it is also stepping into the judicial boundaries as well, and how judicial decision making is going to be affected in future. And of course, a lot of people here spoke about the predictive manner of analyzing what could be a possible outcome. Of course, what was spoken about was the preventive measures that you could take. But I think there is a preemptive aspect to it also, where before anything happens, before the other party realizes, there is a preemptive litigation that is staring at you, or a notice which comes to you. So these are various aspects. I mean, of course, I'm not even going into other aspects like how today perhaps our investment decisions are already being taken care of. So quant computing that's another way. So we don't even need to rely upon any person for the purpose of investing. We simply we enter the data over there, and it will come up with what is the best place for you to invest. And I'm sure in future, in the legal field also, this is pretty much going to be the case. So thank you so much, all of you. And if there are any questions, the floor is open, and please feel free to ask questions. I think Mr. Ganguly is indicating that, he's too weak to ask any question. He needs some sustenance. So please, we can all proceed for lunch. Please. Thank you. Thank you very much.
Thanks to the organizers and the chair.
Very kind.
Very nice. You are doing fantastic. Absolutely correct. Please carry for us, because we are in a transition.
Yes.
Younger generation is not so much scared.
Correct.
Yes.
But I think there's no industry before you actually engage in a conversation with the regulatory authority. You will first have to, figure out where we want to.
Last minute.
Thank you for that. No, I mean, subject. I disagree on having. I was going to talk about it in mind. I disagree. I think it's a good decision. I'll tell you why. Actually, listen, I've sent you. So, what do you think?
So, as general counsel,
ಹೋಗ್ಬಿಟ್ಟಕ್ಕೆ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಸರ್ ಕಾಕೆ ಆಗಿ
Could I please request all the honorable judges and the delegates to join us for lunch? The lunch is going to be a little bit late because we have to start our session at 2:45. So please tell everybody when you meet them at lunch that the session starts. The next session is at 2:45. Thank you so much. Some people are not even bothering to go for lunch, but
It's 1 minute. Just call him. I think it's in the group. Yeah, yeah, it's in the group. No, no, yeah, this is. ಇನ್ಚಾರ್ಜ್ ಫುಲ್ ಅದು ಇದೆಲ್ಲ ಇವ್ರು ಇನ್ಚಾರ್ಜ್ ಗಂಡ ಅದೆಲ್ಲ ಎಂಟಿ ಇನ್ಚಾರ್ಜ್ ಅದಕ್ಕೆ ಇದು ಮತ್ತೆ ಇವ್ರ ಹೆಸರು ಗೊತ್ತಾನೆ ಅವ್ರ ಹೆಸರು ಗೊತ್ತಾನೆ ಆರ್ ಕೆ ಅಂತ ಆರ್ ಜೆ Revolution ಇಲ್ಲ ಅದಕ್ಕೆ ಮ್ಯಾನೇಜರ್ ಬಂದಿದ್ದಾನೆ ಅವ್ನು ಅದು ಹೇಳ್ಕೊಂಡು ತಿನ್ಕೊಂಬರ್ತೀನಿ. ನಾನು ನಿನ್ನೆ ಮಾಡಿದ್ರಾ ನೀವು ಎಲ್ಲ ಡ್ಯೂಟಿಗೆ ಬಂದಿದ್ದೀವಿ. ನೆನ್ನೆನೇ ಇತ್ತಂತ ಇವೆಂಟ್ ಹೌದಾ? ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋದು ಹೌದಾ? ನಾವು ನಾಳೆ ಇಲ್ವಂತೆ ಶಿವ ಕ್ಯಾನ್ಸಲ್ ಮಾಡವ್ರೆ. ನಾಳೆ ಏನಾಗ್ರಾಮಕ್ಕೆ ಹೋಗ್ಬೇಕು. ಮಿಕ್ಸಿಂಗ್ ಅಲ್ಲ, ಬರೀ ಫೋಟೋ ಕ್ಯಾಂಡ್ ವಿಡಿಯೋ ಶಿವ. ನೆನ್ನೆನೇ ಬಂದಿದ್ರು, ಮೊನ್ನೆನೂ ಬಂದಿದ್ರು, ಇವತ್ತು ಬಂದಿದ್ರು. ನಿಮ್ಮನ್ನು ಕೇಳಿದ್ರೆ ಶೂಟಿಂಗ್ ಎಲ್ಲ ಆಯ್ತಲ್ಲ, ಅದಕ್ಕೆ ಫೋನ್ ಮಾಡ್ತಿದ್ವ ನಾವು ನಿಮಗೆ, ರಿಸೀವ್ ಮಾಡಲಿಲ್ಲ ಅಂತ. ಇಲ್ಲಪ್ಪ ಫೋನ್ ಮಾಡ್ತಾನೆ ಇದ್ರು, ನಮಗೂ ಕೆಲಸ ಬರೋದು 1 ಗಂಟೆಗೆ ಊಟದ ಕಾಸು ಕೊಟ್ಟಪ್ಪ, 20,000 ಕೊಟ್ಟ. ಕೊಟ್ಟನಲ್ಲ 15 ಕೊಟ್ಟೆ. ಸರ್ ಜನ ಬರ್ತಾರಾ? ಸರ್ ಜನ ಬರ್ತಾರಾ? ಸನ್ಮಾನ ಮಾಡ್ತೀರಾ ಮಾಡ್ತಾರೆ ತಗೊಂತಿಂದ್ರೆ ಆಗಲ್ಲ ಅವನೇ ಅವನು ಮಗ ಕೋಣ ಕೋಣ ಅವನ ಅಧ್ಯಕ್ಷರು ನೋಡ್ಬೇಕು ನೀವು ರೆಡ್ಡಿ ಸಲೀಮ್ ಅಂತ ಬರ್ತದೆ ಇಲ್ಲ ರೆಡ್ಡಿ ಸಲೀಮ್ ಅಂತ ಬರ್ತದೆ ಇಲ್ಲಿ ಮುಸ್ಲಿಂ ಪೇರ್ పెట్టుకొని ఇంటి పేరు అంటే ఇంకేందయ్యా ನಾನು ಅಲ್ಲ ಅವನು ಟ್ರೂಕಾಲಲ್ಲಿ ಫಸ್ಟ್ ನನಗೆ ರೆಡ್ಡಿ ಸಲೀಮ್ ಅಂತ ಬಂತು ಸಲೀಮ್ ಅಂತ ಗೊತ್ತಾಗಿದೆಯಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಮನೆ ಹೆಸರು ಅದು ಅಂತಾರೆ మొన్న మీడియా చూసినా మేడం కొంచెం బాగా దేవస్థానం చేయించాను ఎక్కడన్నా వాడే ಮತ್ತೆ ತಿಂಡಿಯಲ್ಲಿ ಮಾಡಿಸ್ತಾರೆ ಅವರೇ ಸುಡೋದಿಲ್ಲ ನಾನು ಏನಕ್ಕೆ ಓಕೆ ಸಮೀ ನಿಮ್ಮ ಫುಲ್ ಹೆಸರು ಏನು ಮತ್ತೇನು ಇಂటి పేరు
Welcome back after lunch, albeit a very short one, and apologies for that. But we are now ready with the next session for the day, because in the interest of time, we cannot wait any further. I'm sure the others are going to join soon. This session is on data privacy and security in artificial intelligence, and we are honored to have amongst us Honorable Mr. Justice Anup Jairam Hambani, Judge, Delhi High Court, who is the chair for the session. Honorable Mr. Justice Shyam Prasad, the co-chair, he is Judge, Karnataka High Court. Among speakers, we have Mr. Aditya Vikram Bhatt, Advocate, Bengaluru, Ms. Sarika Gandhi, General Counsel at Lufthansa, Dr. N.S. Nigam,
if we have to do some banking transactions, we don't use public Wi-Fis. We prefer to do them on more secure networks, etc. So let me ask my co-panelists, what is it that AI is doing that is making this worse? Now, before I put out that question, let me take an example. So somebody goes on the net and finds this face of a man who resembles a certain Bollywood actor. So he says, who's this man? This man resembles a Bollywood actor. Is he a Bollywood actor? Then he does a little further research and he finds, no, his name is appearing in the Delhi High Court judges list. So he's probably not a Bollywood actor. He has a much less exciting job of a judge. Then he goes into a Just Dial or one of those other websites and finds the number. That number leads him to a WhatsApp. The WhatsApp shows him, if he digs a little deeper, that this man is part of a group of a certain school, old students association. Let us say the Modern School, Old Students Association, Masosa. So he says, okay, so this boy must have attended modern school. By the way, let me preface this by saying that a lot of the information that I'm divulging to you all now is inaccurate and some of it is completely untrue. But be that as it may, so he says that this boy attended modern school. So he must have been born and brought. You probably have more than 4 rooms in your house. Now this can give the person a profile of your financial standing. So my question is that all of this is already happening to all of us. So what is it that AI has done that we are so fearful of it? Is it just the fear of an unknown animal that we don't understand yet? Or is there something genuine? Now, may I at this point invite Justice Prasad's comments on this? Because before we try to understand what is to be done to secure ourselves from the animal called AI and to secure our data and our privacy, let's first understand and deconstruct what this animal is doing to us. Justice Prasad, would you share your views on this?
Yes, sir. Now, I understand from whatever you have explained, sir, is the problem of anonymity. Having put myself out in the world, I want to be anonymous. I don't want to be known to anybody. Now, I've invited the beast home. And I would say, sir, as you mentioned, that it is mostly self-regulation that could, if in fact there is a beast out there that we create. But sir, my take and what I put out to the audience is in this context. Now this is the picture for an individual. What if I'm an institution and if I'm a repository of data? And if I am an individual and by my conduct I have created a fear when there should be or shouldn't be is one. And if I'm an institution, what do I learn from that experience to ensure that as an institution I do not entertain those fears? My footsteps are definite, are clear. And this question becomes very appropriate, contextual, because as an institution, we are in the early stages of building our database and putting it out in the open. We are not yet put it out the way we put out in the open as individuals. I can speak for Karnataka. Now, we have about 250 crore pages, that is data that contains data, that could be personal data. And we have not scanned perhaps more than 25%, and we have not digitized even 50% of that. Going forward, we will do that. We will do that, and we will put out, as we have put out as individuals, we'll put out that data. Now, we are speaking of privacy, and we are speaking of security. Now, when we speak of privacy as an institution, if as an individual it is, I don't want to be known too much. As an institution, we need to protect that, respect that aspiration, if I may say. But I would also say there could be a responsibility under the statute for an institution. Now, security. Now, why I say it is very appropriate for us to be talking about this, as I said, we're in the very early stages. Maybe we could avoid the pitfalls that we as individuals perhaps could not. Going forward, we will build our data, we'll build our data structure, we'll build our security. No longer the experts are speaking of only firewalls, they are speaking of security for AI. So I'm sure discussions like this will not only help individuals guide themselves to ensure that they have that privacy, which is another word or a synonym for that could be anonymity, wanting to be anonymous, but also the individual, the institution to be more responsible and more towards discharging the responsibilities under the statute if there is.
Thank you for those comments. But if I understand you correctly, when as an institution or as an individual, we begin to use AI as a tool for our work, our personal life, or in any other way, it is what we feed into the system that will decide the outcome. So AI in that sense is like a digital child. If we bring up this child well, then perhaps we have nothing to fear about. But how do we do that? Because
is the $1 million question, or
yes,
much more valuable.
So how do we do that? Because bringing up a child well means giving the child the right kind of education, the right kind of values, and those values, as we know well, a person turns out in the same way as the family he comes from. It is very common. There are of course exceptions to that rule. So what is the dinner table conversation will decide how the child will think. So in cases of an institution, how does that affect anything? Because today if a high court feeds all its data, and I imagine we are talking about certain decisions on certain aspects, and all that information, that content is scraped, it's learned by the language models, and then that model throws up a certain decision. The decision will reflect whatever decisions have been made in the past. So any existing biases in the way that a certain issue has been decided are likely to be replicated.
Can I respond like this, Sam? I will first take the analogy of parenting, which is the most difficult job in the world. Everybody who has been a parent will acknowledge that that's the most difficult job. One could be a husband easily, perhaps a wife easily, but being a parent is a difficult job. Now, the second, saying that, I don't want to feel a parent and take upon the responsibility entirely upon myself to identify. There's no fear, just being responsible about the obligations under the statute to the system that I cater to. I don't want to take upon the responsibility entirely upon myself, saying, I know all, I will do it in-house. But the approach that I would suggest is that we become collaborator. We get the experts experts in the field on board, we talk to them, and we engage them in saying, look, I'm not fearful, but I'm mindful. I want to be responsible, I want to be avoiding pitfalls, and I want to walk the path. So that the system, I am confident, and in my confidence in the system, if I may call it that, the litigant public feeds on that, basks in that confidence, is how I would respond to that.
I couldn't have put it better myself, that we need not be fearful, but we must be mindful. Now, what do you think, Mr. Bhatt, if I may come to you next, what do you think are the biggest pitfalls that we have to be careful about? And how do you think we should go about training these systems in a way that they don't become a Frankenstein monster for us, or they don't become totally, they don't go awry in what they do?
Thank you very much. I just want to go back to one of your earlier analogies on parenting and the child sitting at the dinner table. As parents, we know that our child sits mostly at our dinner table, perhaps a neighbor or perhaps another close friend on occasion. But if this is an animal that we don't know how many dinner tables it is sitting at simultaneously, there is an element of threat over there. So unless we are building air-gapped infrastructure that does not interact with the external world, which is going to be difficult because we are going to rely on service providers and the advent and development of technology to keep ourselves abreast. We are not going to be air-gapped in that sense unless each institution has a state-of-the-art research team in itself. So that, I think, is my first area of concern, that we don't know how many dinner tables this is going to be sitting at simultaneously, and in the guise of repeating my biases, actually what external biases and external influences it is bringing in. One. Two, from the standpoint of practice and institutions that we serve, the judiciary and the public, I just want to put this in context. One is that, generally speaking, sir, when you said that we should, we are somewhat reconciled to our data being out there in the open and the odd occasion of leak, our expectation rises a little higher when it's a fiduciary, a healthcare service provider, a bank, so on and so forth. Now, when it comes to the judiciary, this is the fiduciary of the fiduciaries. So the expectation of the common litigating person and as counsel of the clients that we serve is that as the fiduciary of the fiduciary, this is not an institution that can afford an intrusion. Bringing the topic back to AI, I am not sure we are aware of how intrusive AI can be over the old sort of crawler and bot technologies that are usually scraping data off servers, etc., etc. My sense is that AI-led intrusions can be far more effective and far more lethal. I will conclude, sir, just by saying that as a lawyer, I have learned to trust but simultaneously be paranoid. So I want to diverge from the two leaders on this a little bit. Trust but be paranoid is going to be my mantra.
I think you've put it very well. We don't know how many dinner tables this digital child is sitting at. I think in the nuts and bolts terms, that translates to the fact that if I share, as the example that I gave, if I share my data with a smart speaker for a limited purpose, and that smart speaker is manufactured or it works on an account of a company which also owns an OTT platform, and perhaps a third company that also sells smart watches, and these companies, without my knowledge and unbeknownst to me, they share the data, and all these data points are then put together. So these various platforms being the various dining tables, the dinner tables that the child is sitting on, and all these data points are then collected at scale and aggregated. Now that is what helps build a whole profile of a person without that person being having intended to share the data with all those platforms. So I think you're absolutely right on that. But coming to the point of how and to what extent we can actually control it. Now, of course, we have our new law which has been promulgated. It is under challenge. In any case, we have our constraints to discuss the details of that law. But if I may now come to Ms. Gandhi and ask her that insofar as the new act is concerned, I did a quick run through of the act, and I don't find any specific reference to AI. It is just about data. It is about personal data. It's about a data principle. It is about a data fiduciary. Certain provisions provide for purpose limitations. Certain provisions provide for a data principle saying that please erase my data. So are we even looking at the main nuts and bolts issues in the new act which affect us on a day-to-day basis?
Thank you so much, sir.
And perhaps you can address it from your perspective as General Counsel of a major airlines.
Thank you so much, sir, for putting this question to me. You are absolutely right that the Personal Data Protection Act, DPDP as we call in India, does not talk about AI at all. And if we see the much mature jurisdictions like GDPR from EU, there also it doesn't touch upon AI. But as we have all discussed since this morning, and we are aware of it, that AI guidelines have been published by Government of India, which have the basics like trust as foundation, people first, design and innovation, safeguards, fairness and equity. When we are talking about data protection and AI, we have to take care of all these things as well. There are certain aspects in data privacy also where you safeguards. I mean, we have been talking of automations for an N number of years. You know, in the previous session, he gave the example of autopilot, which has been there for 100 years. But automation, in some way or the other, is affecting our lives for many, many years. And each one of us is wanting to have automized processes. But the governance processes which the Data Protection Act defines, if we abide by those, I think a lot will be regulated on the AI side as well. The data protection talks about DPIA, Data Protection Impact Assessment. Every process where the personal data is collected and processed, if we do an analysis, how it is collected, how it is saved on the system, how it is processed, who all have access to it. If this impact assessment is done, a lot is taken care of. We also talk of privacy by design and default. Privacy by design would mean that when you are designing your AI systems, you have to take care that the data which is going into it, it is secured end to end. These gaps you have to take care when you are designing the system. And that takes care of your AI aspect as well that we have been talking about. I hope I've been able to answer, sir.
Yes, you have, Ms. Gandhi. I might have had a supplementary question for you, but we are again very constrained for time. We are trying to bring the sessions back on track. So maybe I can skip Dr. Sringam for the moment and go to Mr. Shivdas and ask him a follow-up on what I heard towards the end of the last session, that Ms. Gandhi is the General Counsel for a major airlines. Airline ticketing is one of the most, it operates in a very invisible and obfuscated manner, because two people sitting in adjacent rooms can be offered different rates. Now, do you think that the new act is helping? And I don't know if Ms. Gandhi's organization also scrapes data from other sources and platforms to find out who is rich enough to pay more for a flight ticket on her airlines, or whether the new act will take care of that. So, Mr. Shivdas, would you give us your views on this?
Thank you, sir. First of all, thank you to the organizers. I think I'm the youngest panelist today, so there's a lot to learn from all of you, so thank you so much. Sir, DPDP does not answer that question. We are in the process of creating something known as a Digital Markets Act under the competition law regime that does, clicks, number of clicks that you have on Google, etc., or the number of times you click on a certain activity, or the IP with which you access all of these websites, etc. These are all targeted under that. TPDP does not cover any of those aspects. But I'll dial back a little bit to the problems that are there in AI and take lead from where Aditya left. I think one of the biggest concerns about AI is the ethical sourcing of data sets that is built into the LLM module, which ultimately creates the application. Now, there have been problems about how the language is being developed and how it's being trained because of the fact that the ethical sourcing of data is not happening. If for instance, today, if I were to go on Google and if I want to type a research case point, the first segment of Google results is a Google Gemini AI result that most of you would have seen. And then you have the actual number of results that are popping up at the end of it. In each of those Google AI results, you will see number of footnotes and the citations that are mentioned against each of those points. 1 or 2 points will definitely not have any kind of footnote. Now that is the problem of the training of the AI, because it starts hallucinating within itself and trying to pick out various models that have been developed over time, and it starts reasoning and thinking by itself. The other problem that is there is the fact that the AI module by itself lands into trouble with the purpose limitation concept that is there in the DPDP or any other data protection legislation for that matter. Because if I'm a customer who gives consent for a certain activity, I have control over the data. The minute that that purpose is achieved, suppose there's an Amazon delivery that needs to come home, the delivery is achieved. Technically, as a data principal, I am the person who holds the data and says, I want it to be deleted or I want it to be kept with you for a future transaction that I want to do. That in AI might be a problem because AI as a concept is self-learning. So it continuously uses the data and the inputs that you give to be able to use that information to develop its own learning processes as well. That's where I think one of the AI applications got into a problem, because I think a child wanted to understand the concept of mental health and it landed the child in a little bit of a soup. So those are problematic areas where you give access to children where they don't know what and how the AI is going to react. So that's the little bit of a security problem. On the possible aspect of how this problem can be solved, Sarika mentioned that I think there's a little bit of privacy by design concept that's going on within the DPDP segment. That needs to extend when you're doing the learning process and the LLM carving process when you're developing the app itself. Because that will decide how the bias is framed, only that will decide what are the kinds of output it gives you. And like you said, I think your initial comment was what you type in gives you the kind of result that you want to achieve. Now, the typing in is also a unit factor for the AI tool to create its own kind of leveling of data. So that's another problem that's there with the AI process. To answer your question on how this problem on ticketing or marginalized, I don't know how to put it across, but if there is a certain section of the society that wants to pay more, or if there are certain hotel aspects that are coming in, etc., there are a lot of these black box events that happen during the processing of AI process. That also stems from a security problem, because once the AI is placed as a proper application for people to use, there are a lot of security failures that go in, that creep in, because of which there are certain IP issues that also lag in. So DPDP might not be the right answer. Possibly the AI guidelines could help us with understanding this problem. Europe has already gone into this concept of EU AI Act, where they're regulating the AI as a concept, and they have 3 different tiers of how each of the AI applications need to be used. There's a low risk, there's a medium, and a high risk. Healthcare, for instance, finance, for instance, are highly high risk level AI tools, and the remaining follows from that. So maybe perhaps we could have a little bit of a learning from Europe, but customize it to the Indian audience, because we are not used to privacy. I don't think Indians are ever used to the concept of privacy. I don't think we know what a data privacy means or what a security breach means. I don't think I've ever gone home when my dad doesn't ask me, what are you doing and how are you not doing and all of that. So that as a society we need to develop more, and maybe the law will help us with that as too.
So I quite see that that point, that we as a society are not much, we don't care much about privacy. If I may also point out that when I click I agree to a consent terms, and I'm somewhat of a literate person, I have never ever read what I said I agree to. And then there are silent updates to those terms and conditions which one never finds out. No one has the time, and in fact, most of it is in English, so I don't know whether it is at all relevant when it is put out to us. So on that note, coming to Dr. Snigam, now from what was just said by Mr. Shivdas, it is very difficult to actually know whether you have consented to sharing your data. So perhaps, and also, as he said, that even if I ask for deletion of my data, their AI systems have already learned things on their own, so their knowledge can't be unlearned. That bell can't be unrung. So therefore, as an academic, do you think that the involvement of some ethicists or some social scientists at all in the training process of AI models is necessary, and is that at all happening?
Thank you, sir. No, I don't think that's happening, at least on a scale that we need it to happen. I think the discussion so far has really brought out how different avenues are open to us at this stage to regulate AI. We've been talking about the consent-based model to regulate AI, and that's just one of the models, I think, on the table. We have already seen in this panel discussion the problems with a consent-based model. The problems are that sometimes a consent-based model really doesn't take into account the fact that the population that is consenting is not giving much thought to it. And then if you try to implement a consent-based model of the sort that we are discussing, then we'll have to go into a host of other issues in any legislation that focuses on that, including the very definition of what personal data is. Can there be exceptions where you don't need consent? So for example, for research purposes and for those kind of purposes, for academic purposes, for research purposes, for purposes of the government. I'm not sure at this early stage that we should be confining ourselves to just one model of governance, and that we should explore other models. We are at an early stage. At the stage, AI and its technology regulation is at a stage where I think we should explore rather than limit ourselves to any one particular model. And I was just going to suggest that these are not novel ideas. We've already seen how in Europe and other places they're also experimenting and trying to figure out how we can have harm or risk-based models of AI regulation, where when they want to regulate how AI scrapes data from various sources, and we've been talking about multinational companies that have various social media platforms, and they can then create a profile of a person based on scraping information from various social media platforms. You started your example with that, except that now AI can do it at scale
Yes.
rather than at
much faster, at scale,
right.
much cheaper. But it could be completely wrong.
So there, I'm not even sure a consent-based model may work. I think that we might have to explore other ways of regulating that.
Is it, just as a last question, Dr. Singham, is it possible to have, by way of law or by regulation, a module of AI which should be embedded in any and every AI system, which ensures that there is no sharing of information except as permitted and as agreed to by the data principle, and which ensures that biases are avoided? So can we first create an AI module which can eliminate bias in other AI modules?
Yeah, I think that'll be, that would come under perhaps under the subset of AI by design. But the problem is those kind of models are extremely hard to do. And we might have a certain amount of path dependence already set in here, that we have already gone on a certain path. I was just thinking about some early scholarly work on our apps. The fact that all our apps are on a mobile phone, placed in a certain way with easy access, itself was a design choice, which now we take it for granted. But that was a design choice that has led to where we are now. So I think you're right that we need to think about it from a design point of view, but I suspect it'll be extremely hard for us not to take any steps back.
Very well. Thank you all very much for your very erudite comments. I'm afraid we'll have to cut short this session. So thank you all so much, and on behalf of everyone, I thank Mr. Ganguly and UIA for inviting us for this very interesting session. Thank you.
In the interest of time, we quickly move off to the next session. And this session is on artificial intelligence in contracts and documents, chatbots and negotiation assistance. So, we are honored to have Honorable Mr. Justice Sunil Dutt Yadav, Judge, Karnataka High Court, as the session chair. The co-chair for the session is Honorable Mr. Justice Tejas Karya, Judge, Delhi High Court. The honorable speakers are Mr. Shyam Sundar, Senior Advocate, Bengaluru, Mr. Karan Joseph, who is partner at Shardul Amarchand Mangaldas, Bengaluru, Dr. Sudhir Krishnaswamy, Vice Chancellor, National Law School of India University, and Mr. Vikram Hegde, Advocate, Supreme Court of India.
This one?
Hi everyone, good afternoon. I know we're all pressed for time, so I thought we'll just jump straight into it. It's a pleasure for us, for the panelists here, to share the stage with Justice Yadav and Justice Karya. So if we could just start with you, sir, Justice Yadav, in terms of, so do you want? Okay, so slight rearrangement. Justice Tejas Karya unfortunately has a flight to catch, so we're going to let him start. Sir, would you please begin?
Honorable Mr. Justice P.K. Upadhyay, Chief Justice, High Court of Delhi, my esteemed brother and sister judges from High Court of Karnataka and High Court of Delhi, Honorable Mr. Justice Sunil Dutt Yadav, Judge, Karnataka High Court, Mr. Shyam Sundar, Senior Advocate, Bengaluru, Mr. Sudhir Krishnaswamy, Vice Chancellor, National Law University, Bengaluru, Mr. Vikram Hegde, Advocate, Supreme Court of India, Mr. Karan Joseph, Partner, Shardul Amarchand Mangaldas. So the topic for this session is AI in contracts and documents, chatbots and negotiation assistance. When we talk of contract drafting, essentially contract is purely an articulation of human will. It is basically premised on an ability of individuals to make choices and bind each other by entering into the contract. What we have seen with the advent of artificial intelligence in domain of contracts, negotiation, and analysis of the document is that it offers a new dimension to the contract drafting and negotiations. The fundamental principles like consent, offer and acceptance, consensus ad idem, and also the intent to be bound by legally enforceable agreement are now not seen in abstractions. They are in essence the expression of party autonomy, and they reflect the basic idea that the individuals are free to make their own decisions and enter into contracts by choice. Now AI is rapidly changing the legal industry through automated document review and platforms capable of drafting complete contracts. These innovations offer significant efficiencies and the cost reduction to the businesses for contract management. However, reliance on AI for generating critical binding agreements carries significant risk, as errors can result in costly legal and regulatory challenges. Contracts basically as foundational instrument for managing business relationships, delineating responsibilities, and establishing the protocols for dispute resolutions. Now, if we have errors or omissions or ambiguities within the contractual framework, it may precipitate litigation, regulatory scrutiny, or expose considerable financial burden. As such, the legal professionals strongly advise against a sole dependence on AI-driven solutions for contract drafting and evaluation. Today, the contracts can be drafted within seconds. Negotiation strategies can be suggested and sometimes even carried out by AI systems. Legal documents, which once required careful human effort, are now generated through simple prompts. These developments bring speed and convenience. They promise to make legal services more accessible, but they also raise important questions that the law cannot ignore. AI models are trained on exclusive data sets, but their reliability is contingent on the scope and timelines of the data used during training. They do not possess the capability of incorporate the real-time updates concerning the new statutes, judicial decisions, or regulatory amendments. Imagine an AI is drafting an employment agreement without the latest provisions from the law or the regulations, resulting into a contract which may suffer from legal penalties or employee grievances. Human involvement in drafting and negotiating contracts can actively monitor developments in the legal landscape, a task beyond the autonomous reach of the AI systems. The integration of AI-driven systems into contract drafting necessitates a reassessment of whether established doctrines maintain their relevance as drafting, advisory, and negotiation activities become increasingly algorithm-driven. When document chatbots generate contractual clauses, they rely on pattern recognition rather than genuine understanding. Similarly, negotiation assistants suggest terms based on embedded optimization functions, not personal judgments. This evaluation presents a critical legal issue whether outputs derived from such systems can be legitimately attributed to human intent. The answer cannot be simplistic. To characterize AI solely as a passive instrument, like comparable to a pen or a typewriter or a computer, overlooks its capability for autonomous operations within specified boundaries. At the same time, categorizing it an independent legal entity mistakenly assigns agency that AI does not genuinely possess. The legal challenge is to navigate the space between these two perspectives. One viable solution is to revisit the attribution of liability. Traditionally, an agent's actions are imputed to the principal based on authority and control. However, AI systems pose challenge to this basic principles. Sometimes the outputs are even not known to the principal, and what happens consequently is, as a mere nuanced framework for distributed responsibility may be required, with the liability allocated amongst the developers, deployers, users, according to the extent and nature of their involvement. For instance, with a chatbot drafts a contractual clause, it lacks true understanding of its content. When an AI tool proposes the terms during negotiations, it does not exercise human judgment but relies on data and patterns. If a party accepts these suggested terms, one must consider whether this acceptance is genuinely informed or substantially influenced by a system whose functioning may not be fully understood by the party. If a dispute arises and one party has relied extensively on an AI system, disclosure of this reliance becomes pertinent. Should the court or arbitral tribunal be afforded insight into how AI influenced the contractual terms? These questions are complex. On one hand, there are legitimate concerns regarding proprietary and technology. On the other, fairness requires parties to have ability to comprehend and contest the foundation of the agreement. Equally significant are the implications for issue of consent. The law has long insisted that the consent must be free, informed, and untainted by factors such as coercion, undue influence, or misrepresentation. The use of AI systems to generate or assess contractual terms alters the foundation of the consent. Parties may accept terms not based on their own independent analysis, but rather due to algorithmic recommendations. This evaluation prompts the question of whether such consent can genuinely be considered as informed. Although AI-generated text may exhibit high degree of professionalism, it is susceptible to ambiguities, inconsistencies, or omissions. Unclear contractual language is frequent source of dispute. Issues such as misplaced modifiers, undefined terms, or contradictory obligations can result in costly litigation. For instance, an AI-drafted non-compete agreement might lack sufficient specificity regarding the geographic scope, making it unenforceable. Consequently, the courts may refuse to uphold contracts that lack clarity, and AI's current limitations increase the likelihood of drafting provisions that are legally confidentiality, and intellectual property. This is not solely a technical challenge, but also engages fundamental principles of natural justice, ensuring that the parties have a fair opportunity to understand and contest the foundations of their contractual relationships. The integration of AI assistance into negotiation process is introducing subtle but substantial changes to the dynamics of bargaining. Traditionally, negotiations has been characterized by direct human interactions. In contrast, AI systems treat negotiations as an optimization problem aiming to maximize specific objectives using available data. While this approach can increase efficiency, it may also risk reducing negotiations to a mechanical procedure lacking the contextual sensitivity inherent to judicial participation. Within the legal context, in India, although there is no explicit statutory provision regarding regulating AI in contractual arrangements, Indian Contract Act, despite its historical origins, codifies broad principles amenable to modern forms of interactions. Provisions concerning consent, mistake, and misrepresentation may, when interpreted thoughtfully, apply to disputes involving AI-generated contracts. Likewise, the Information Technology Act, which affirms the validity of electronic records, electronic signatures, establishes a foundational platform for further doctrinal advancement. It remains clear, however, that judicial interpretation, though indispensable, cannot fully replace legislative action. The complex issues presented by AI, such as liability allocation, standardization, and ethical oversight, demand comprehensive legislative and regulatory responses. These measures must be informed by multidisciplinary insights from law, technology, economics, and ethics. It is prudent to conclude that automation should not diminish the rigor associated with legal accountability. Over time, the reliance may transform traditional legal practices, shifting lawyers' role from advisor or an advocate to supervisor of technological systems. While such developments may improve operational efficiencies, they simultaneously prompt critical questions concerning the preservation of professional judgment and ethical standards. The prevention of human agency is imperative. While artificial intelligence can facilitate, enhance, and inform decision making, it must not replace the essential capacity for judgment which forms the foundation of legal responsibility. It is critical that the accountability is maintained with stringent enforcement. The decentralization of decision making across technological platforms must not lead to diminished liability. Legal frameworks should ensure responsibility remains both traceable and enforceable. The judiciary should adopt a methodology that balances cautious restraint, recognizing the boundaries of judicial intervention in technical matters with creative doctrinal development that responds to novel technologies while remaining rooted in enduring principles. Legal evaluation has historically been shaped by the balance between continuity and innovation. The application of AI to contracts and negotiations embodies significant change. Our objective is not to resist progress, but to ensure its alignment with the foundational values that reaffirm that while the law may adapt in structure, its purpose must remain resolute. Ultimately, the pertinent question is not whether machines are capable of cognitive tasks such as drafting or negotiation, but whether amidst intelligence systems, we can maintain the integrity of human judgment and uphold the primacy of justice. This inquiry, in my view, will define the forthcoming era of jurisprudence. Thank you.
Thank you, sir, for those thoughts, particularly on the interplay between the Contract Act and AI-related contracts. May I now call on stage Justice Sunildat Yadav. Sir, could you please tell us what your perspective is in terms of how the courts have seen a transformation?
Honorable Chief Justice Sri Upadhyay, all senior judges, delegates. My short talk is meant to be only a preamble, as they are domain experts dealing with the subtopics. AI could be seen both as an opportunity to expand access to legal services and has also turned out to be a challenge to the existing institutional architecture of justice delivery. If an idea has come to stay, none can resist. The question therefore is not whether AI will enter the processes of contracting, negotiating and drafting, but how we as members of the legal community will shape and govern its use. So indeed, if deployed responsibly, AI can expand the reach of good lawyering rather than erode it. Cynicism has turned to cautious optimism and acceptance. AI is a useful tool in the right hands. However, it could be mischievous and embarrass you at the most crucial occasions with nowhere to hide. The acceptance of AI is revealed by a survey by Manupatra, which states that 74% of legal professionals have interacted with AI generative tools. It is also stated that AI could automate nearly 44% of legal tasks. AI would allow us to reserve scarce human judgment for genuinely hard questions of strategy, ethics, and interpretation, while delegating some of the mechanical work to AI. Furthermore, AI contributes to democratization in access to legal services. Individuals and smaller organizations such as MSMEs may find that for routine tasks, formal contracts can be by taking recourse to near ready-made templates. Similarly, efforts of the Supreme Court in translating using tools like SUVAS for translating judgments is another such effort in AI adoption for expediting routine tasks and democratization of access of judgments to the local population. AI may generate generalized drafts but cannot substitute a lawyer in negotiating, making nuanced concessions, and deciding how to structure clauses to save a deal. It may, many a time, give a false sense of security and may result in passing of clauses without a deep scrutiny. With that background, and conscious that we have other panelists who work at the cutting edge of these developments, a few of the questions that may come forth through the conversation are: to what extent can AI genuinely assist strategic decision making in negotiating and drafting of contracts and documents, and at what point does reliance on such tools begin to dull the instincts of a good negotiator or draftsman? Secondly, the problem of hallucinated or fabricated information finding its way into legal documents is already visible. What safeguards can the profession put in place to address this, and how do we ensure that the standards of professional responsibility are not diluted when AI is used? Thirdly, our contract law assumes that there are human minds on both sides, that there is privity between identifiable parties, and that there is an intention to create legal relations. As we see more AI to AI interaction, bots that accept offers, trigger renewals, or even negotiate routine terms with minimal human oversight, what pressures will this place on the doctrinal foundations of contract law? Fourthly, for students and young lawyers, these tools are already an integral part of their daily lives. How do we teach responsible use and at the same time ensure that they still acquire the fundamentals of contract, sound drafting, negotiation strategy, and sector-specific practice? These are not abstract questions, but go to the heart of what we do in courts every day, determining who bears risk, what was fairly agreed, how to interpret the words that parties have chosen. AI will undoubtedly change the way those words are produced, must not change who is accountable for them or the purposes they are meant to serve. I thank you for this opportunity, and hopefully the conversation between the other panelists will throw light on some of the issues raised. Thank you.
Thank you, sir. Justice Tejas Karya for taking the time to be with us. And we hope he makes his flight. Bangalore traffic is, well, notorious, and hopefully he makes it. Thank you, Justice Yadav, for framing those 4 questions that I hope we will have answers to. What stood out to me of those 4 questions were, one, that we need to develop some form of safeguards for the use of AI. And second, perhaps most crucial, is how do we train not the AI, but lawyers and students to still use those gray cells or brain cells and not really defer it or delegate it to AI. To our guests from the Delhi High Court, Chief Justice Upadhyay, Justice Bambani, Justice Shankar, to our host judges from Karnataka, Justice Jayant Banerjee, Justice D.K. Singh, Justice Shyam Prasad, Justice Krishna Kumar, Justice Suraj Govindraju, Justice C.M. Joshi, senior advocates, my brothers and sisters from the bar, welcome. So I do not draft contracts. I very rarely have or am involved in the drafting stage. I, unfortunately for the parties and perhaps fortunately for me, inherit them when they reach the dispute stage, when that relationship really has broken down between the parties and they come to us to try and come up with something ingenuous to try and fix, and we have to try and attempt to convince the bench that our interpretation is right. So I want to deal with 2 Indian scenarios, hypothetical, of course. The first scenario, a problem perhaps that I foresee, is a localization problem. Most AI, at least the popular ones that we are aware of, are foreign in a sense. So let's assume that there is a supply agreement between 2 Indian companies. There is a force majeure clause. Now this force majeure clause is drafted by AI. It runs into 4 paragraphs. It's extremely well written. It's in flawless English, structured very well. It'll describe qualifying events, it'll describe mitigation obligations and suspension rights. But this AI has been trained based on foreign jurisdictions, which read force majeure clauses broadly and in a commercial sense. The AI perhaps may not know that, for instance, after the Supreme Court's decision in Energy Watchdog, that Indian courts construe these clauses very strictly. Now, no lawyer has reviewed it carefully. It's been plugged into the contract. So when the party seeks to enforce this force majeure clause 2 years later, they're going to trip up in its implementation and execution. Second, let's assume that there is an M&A negotiation between 2 Indian parties. One side's counsel uses an AI drafting platform to prepare an NDA. Now all of this, anything that goes into an NDA is obviously confidential. So they upload the client's preliminary term sheet as context. Now the term sheet goes into that platform, and what the vendor contract permits the platform to do with that data, whether it can be retained, whether it can be used as a training model, what happens to that data set, no one has checked. Now, of course, insofar as India is concerned, there is the Digital Personal Data Protection Act, which is in force. So when a lawyer uploads a client's confidential data to an AI drafting platform, and in all likelihood that data will contain personal information, as most commercial contracts do, the vendor becomes a data processor. Now, most, other than enterprise AI, which means your paid AI platforms, most of them, when they operate on a free model, for instance, there are questions as to how that sensitive information is going to be used by that AI and how it's going to be retained. Now, of course, India has not really reached a situation where we've had to deal with this in the court context, right? But there are two very recent examples as of just a month ago from the US. Two conflicting decisions. There was, one is Hepner, where the defendant was this is in the Southern District of New York, and this Mr. Hepner is facing a grand jury indictment. So as most clients do, and I think the lawyers in the room will empathize, this Mr. Hepner has put all his information on Claude, which is Anthropic's AI. He's asked it for advice. He's put in all of his documents. Subsequently, the FBI came and seized all his computers and all his documents. His lawyers went to court and said, we should keep this out because it constitutes attorney-client privilege. The Court of New York said, no, I'm sorry, that's not possible because for a couple of reasons. One being, it appears he was using the free version. Then Claude is not a lawyer, so there can't be an expectation of any form of attorney-client privilege. Claude, in fact, when you give it legal advice, says, please go ask for legal advice, I'm sorry, is very clear that it's not legal advice and you should go to a lawyer. He did not do this at the instance of his lawyer. And what really stood out there was also that the court said, look, the key to an attorney-client privilege is the fact that an attorney has to have some sort of guardrails within which to work under, which Claude does not have. There's no supervisory board and it's not subject to discipline. 1 week later, a court in Michigan had dealt with a similar situation to do with privilege. This time it wasn't Claude, it was ChatGPT. And the court said, look, this is not a third person. If you were to give out information to a third person, perhaps there is no privilege, but you are using a tool. And therefore, it is privilege. Now, to my mind, when I read both judgments, I feel like what changed the mind of the court in Michigan was the fact that the plaintiff there was representing himself. So then the court made that distinction and said, look, if you're representing yourself, it's like you are your own lawyer, and therefore, this privilege will apply to lawyers. So the good news is it appears that the courts are of the opinion that if lawyers use AI, we're okay. It's just that parties shouldn't. Which brings me to my last point, because AI, which is enterprise software, for instance, which is what all the big law firms, the big institutions use, have their own guardrails. It's not, you may not necessarily have to train a data set. My question, and I'm hoping either we think about it or someone can answer, is how does this affect your local lawyer? Because all of these enterprise softwares come at a price. So does that mean, is there an access to justice situation here? Because an independent lawyer, for instance, when he's looking for some form of aid, is just going to put this in at the last minute and try and get a solution. So is there a asymmetry there? And I'm hoping that someone can answer that. Thank you.
Honorable Chief Justice Upadhyay, Honorable Judges of the High Court who are with us today, respected advocates and delegates. May I begin by thanking Senior Advocate A.K. Ganguly and Avi Singh for the invitation to be a part of this panel and conference. Karan and I agreed that we would take a little under 6 minutes each, so let me get straight to the point, otherwise we're already way over time. I'm going to pick up from some of the points that Justice Karya made as we started this panel and push in a slightly different direction. So the first point I wanted to make was that Justice Karya suggested that AI opens up new risks. But I want to develop a baseline against which these risks should be judged. Over the last 2 decades, contract law has developed in a direction driven by the internet and electronic contracting that standard form contracts have become the norm of contracting. These are essentially, take it or leave it, unilateral contracts that all of us sign. It may have the benefit of certainty, but it does not have the benefit of a consensus between parties. So the baseline for electronic contracting is already tenuous on the question of consensus ad idem, because all of us, as the standard terms of service agreements that we sign up to on various matters, just press agree or disagree, in which case you opt out of the platform. There has been one recent exception to this, and that has emerged out of privacy legislation. Initially with the European efforts around the GDPR, and now when the DPDP Act kicks in full around Indian legislation on these questions. When we are asked in a DPDP Act context to choose the level of information sharing that we agree to, we are already working at a customized contract. Now, this has not occurred across the scale of issues, even on standardized electronic contracts, and hence here is where the opportunity for AI-based contracting arises. Why do we not have customized contracting on the internet? The standard argument is that the transaction costs of millions of negotiations potentially between platforms and users is simply not feasible. It's too expensive. And hence, standard take it or leave it contracts are possible. That's the only thing that's possible. To this, we must introduce the idea that agentic AI can do two things. A, it can negotiate. B, it can write the contracts. Suddenly, automation raises the prospect that we can move away from the current model of contracting on the internet and develop and resurrect almost the principles of consensus which stand at the core of contract law. So Justice Karia seemed to suggest that consent would come under pressure, and I'm going to suggest that consent may get a new life in AI-based contracting. That's point number one. If we get that going, if we get automated negotiation going of contracts and writing of contracts, what could the risks be? And on this, I agree with Justice Karia that we have at least three significant risks. First, that our entire model of principal-agent relationships will be tested. So we all know that principal-agent relationships are driven on the conceptual basis of a scope of authority. And the question as to what is the scope of authority granted to an agentic negotiation engine will become critical. So it is not unsolvable as a problem, but the way I would look at it is the way we look at automated car liability. So in the car scenario, we have what are called ADAS tiers. Some of you might already be familiar with it. And the tiering of the automatic detection systems allow for different levels of automation. At the highest level, we think and we still hope that the machine drives itself. But we know that at the lower levels, they give you accident warnings. As you know, ADAS 1 and 2 systems are already on Indian roads. So I take it that some of us have already benefited from these tiering systems. So we might find in automated negotiation a similar tiering. And a certain level of tiering will attach itself to certain levels of liability. That is happening in automated vehicles, and we might need to bring something like that to this arena. Automated negotiation will seriously test the distinction between legal and natural persons. Now, we drive consent based on the idea that there are persons at the other end, or at both ends of the contract, And we have to now deal with the possibility that at least one end of the contract might not have a natural or legal person. Now, we might then still go back to a principal-agent relationship and say that, yes, it's an automated agent, but the agent is simply the agent of a principal. And we might be able to solve this problem. But we have a conceptual terrain of consent in contract which is defined around the idea of natural persons. And hence, we will have to rethink this space as we go ahead. Let me stop last, and I think Justice Karya mentioned this, but let me just say a little bit more about the idea that many of the concepts we use in contract law, the concept of mistake, the concept of misrepresentation, and so on, turn on the idea that a party has applied their mind to a particular phrasing and either shows varieties of fault, misfeasance, malfeasance, nonfeasance. Now, when we are dealing with agentic systems, how would we work with the varieties of fault? That will become a critical question in contract law. Does it mean that concepts of mistake and misrepresentation go away altogether? And that's not where my bets would lie. I think 10 years from now, we will still be teaching students of contract law, mistake and misrepresentation. But we will have to rework our ideas of nonfeasance, malfeasance, and misfeasance for it to be productive in this context. So I've just taken a quick stab at some conceptual work in contract law and leave it to my other panelists to pick it up from here. Thank you.
Thank you, Dr. Krishnaswamy. And that adaptive nature, I think, segues well into Senior Advocate Mr. Shyam Sundar's work on dynamic contracts.
Good evening, everybody. Honorable Justice Sunil Yadav, my fellow panelists, Honorable Justice Bambani, Honorable Justice C.N. Joshi, Honorable Justice Banerjee, Honorable Justice D.K. Singh, the Honorable Judges, Senior Advocates, Honorable Justice Krishna Kumar, my friends. Having been a stand-up talker and having been a teacher in a college for some time, generally when I come and address, the flow is easy. But when you know that there is one person in the audience, particularly given the subject of the day, who knows too much more about the subject than you, you're a bit nervous. And I'm sure that there is one gentleman, His Lordship Justice Suraj Govindraj, who is extremely good on these electronics, computers, digital, data, and all these things. Therefore, I'm being very conscious of my today's delivery. I've taken a little labor to get into the subject and to be very conscious of what I'm going to say. I'm afraid if we are mistaking artificial intelligence for automated mechanics. One of the learned spokesperson today said that we have this artificial intelligence on the aircraft from past 100 years, that is the autopilot. I'm afraid if autopilot is artificial intelligence, autopilot, these concepts, the calculator, that you know you have designed the machine in such a way that you know what it has to do, what it can do, and what it should do. In my view, the artificial intelligence is something more than this. Artificial intelligence is not that autopilot which cruises the plane from a particular destination at a particular cruise speed to a particular destination. Artificial intelligence can be that overwhelmingly and criminally thinking. If the artificial intelligence is put completely embedded on an aircraft, if at least 80% of the passengers on the board or rock music lovers and the party lovers, instead of landing them at Delhi, it would rather take a decision on its own and land them at Goa. This is what is the danger of artificial intelligence. In fact, there are some of the judges, we have been witnessing these incidents, as some of the judges at the trial courts and some of the judges have been using this artificial judgments and citations generated by the artificial intelligence. Now, why the artificial intelligence is doing this? Artificial intelligence, if there was a ready citation available, it would readily deliver it to you with the citation number, year, the report, etc. If the citation is not there, if there was no decided case law on the subject, then the artificial intelligence would think, what if there was a case like this, and what could have been the judgment aligned to law and aligned to so many other aspects of the lex loci. This is how the artificial judgments, hallucinated judgments are brought out. Now, don't look at the citation of the artificially created judgment, but look at the theme of the artificially created judgment. It is trying to tell us something, that this could be the better way of judging. It is good at times and it is highly dangerous at times. Because one of the speakers said, we are trying to use the artificially created products without being in that ambience. But suppose you have a justice delivery system in London or in England which works on different aspects. You have a justice delivery system in our country, this works on different aspects. Different demographies, different constitutional provisions, different legal provisions. So the judgments and the analogy created there cannot be directly imported here. Therefore, the artificial intelligence has to be first geofenced. If you are using the artificial intelligence of some other area, then we are erring. So it should be a geofenced artificial intelligence what we have to focus on. In Indian judicial system, if we are using the artificial intelligence, the data that should be fed should be the local data. If you are importing data from the other sources, then there could be a very special situations which could be strange, which could be funny, which could be extreme. Now, coming to the topic of the day, the contracts. Now, of course, it's quite easy to draft a contract these days using artificial intelligence. You need not to labor much upon. You want to draft a sale deed, you just give the name of the parties, you just give the name of the details of the property, a beautiful sale deed is designed for you. Now, this is at the time when you create a contract. Now, how do you manage a contract? I believe the artificial intelligence has to be used more in managing the contracts than creating the contracts. Now, why do so many contracts, so many agreements get into a disputed situation? At least 5 out of 10 contracts in corporate working gets into courts, gets into commercial courts, gets into arbitration. Why is it happening? The contracts, when they are made, are stagnant. They are drafted on that particular day to that particular situation. Now, by the time the implementation time comes, now there is a lot of water that has flown under the bridge. There's a lot of development that has taken place on the side of law, on the side of policies, on the side of how the courts have looked at various things. Now, you don't have the dynamism in the contract. It's only when the management of a contract is made over to artificial intelligence, it will certainly be a greater take and a matter of greater deal for us, because the artificial intelligence can certainly guide the contractual parties to say when to do what. If suppose there is an option in the contract, there's a put option in the contract, there's a call option in the contract, there is a compulsory redemption option in the contract. The artificial intelligence, after analyzing the market, analyzing the situation, analyzing the financial health of the parties, can certainly guide, do this at this time. Now, these days we have been seeing the number of cases that are increasing in NCLT, that too concerning the IBC. Now everyone wants to go and file a section 7 or a section 9. Now if we productively implant the AI into contracts, perhaps tomorrow we will be guided profusely by the AI whether to go to NCLT or not, whether to pull a company into the insolvency process or not. Is it healthy? Does it work to you as a solution? Sometimes you might win a small claim against your opponent, but that small claim can cascade into a bigger issue. Therefore, my take on usage of AI into contracts is not just designing a contract, is not just molding a contract, but to ensure that the AI is employed more in managing the contract, where it can certainly guide us whether there is a disputed situation, how to manage, especially the timelines, reminder of the timelines, when to do what, whether there is a financial policy which is still convenient to the contract which we have drafted, is there any change in the circumstances. These things would certainly be more beneficial if we take AI into management more than creating of it. Creating of it we have done enough. Now, there's one more observation which I made. I made an attempt to ask AI to draft a bail petition for me under section 167 subsection 2, that is the compulsory bail, if the charge sheet is not filed within time. It just made a bail application for me which was only 2 lines. The statutory period for filing the charge sheet is over. Please grant me bail. This was as precise as this, and this was as simple as this. There was nothing more that was required. And I made an attempt also to ask the AI. I've been in jail for 5 years being accused of murder, but now my situation has gone pathetic. There is no one to take care of my parents at home. There is no one to take care of my children at home. Please draft a bail application for me on compassionate grounds. It ran into about 10 paragraphs telling I'm in a pathetic condition, I don't have money, I don't have means. This is how the AI can think, importing the legal requirements by taking all those ideas from the existing law. Now, of course, at this age where still the usage of AI in the contracts and legal aspect, we are still developing it. After 10 years, we'll have more well-drafted, well-nurtured AI responses that would be coming to us. The AI responses as of today requires, of course, a correction, a second look, a redrafting, a remolding of it. Using of the AI straight away and putting it into practice could be dangerous, and I would rather conclude to say, especially in the areas like IBC, in the areas like contract management, in the areas like the loan management, the lawyers who are practicing on these areas, we should certainly use AI for the management of the contracts, which will be more beneficial to us. And AI can also certainly gauge the ongoing situations. Like suppose if you are into a petroleum contract, AI can certainly screen through what is the availability of the petroleum across, what are the factors that are hitting the supply of the petroleum product, and so many things. Therefore, AI is more beneficial if it is used for the management of contracts when it comes to contractual arena than for making of it, as we have sufficient acumen for making the contracts than managing the contracts. Management is always a greater task than creating of it. With the last example, I would wrap up my words. That trial of Socrates, when it took place, there was as many as a jury of as many as 50 members, and all the jury members were chosen by a lot to eradicate even the least possible bias that a particular jury member is picked and chosen, etc. When the trial ended, at least it was perhaps 60-40% opinion that 60 of them said he should be convicted and at least 40 of them said no, he should be let free. But the majority prevailed, the conviction took place, then came the awarding of the sentence. Whether should he be given the capital punishment or should he be given a lesser punishment. Interestingly and very strangely, the percentage which opted for giving him capital punishment was more than what was the percentage of the jury members which are opted for whether to acquit him or to convict him. Now this is how the human mind changes its thinking, its priorities. At different times our priorities are different. We think differently given a different situation. I am afraid if AI can do this given the judgmental process, that is the reason what I would say as of now is that we give least to the AI's hands when it comes to decision making. We give more to the hands of the AI when it comes to the preparation part of it. Let it be predictive, let it be guiding us when it comes to molding or more constructing, but when it comes to decision making, I believe we use less AI and we use more of our own knowledge and acumen. AI can be a great tool, but AI should never become a decision maker. Thank you.
Thank you, sir. A very warm welcome to Justice Vikram Nath. So we just have one speaker left. We promise we won't take too long. Vikram, over to you.
I take the occasion to extend a welcome to Justice Vikram Nath, who has just joined us. Yes, yes. Yes. And I'll extend my greetings to all the honorable judges, the senior advocates, lawyers, and delegates in the gathering. I'll start by drawing strength from one of the rare optimistic notes that has been struck today by just Professor Sudhir Krishnaswamy in saying that yes, AI is going to really change the way we work, and does that necessarily mean a bad thing, or is it just a question of change which we have to adapt to? And if we have to adapt to, what is it? What are these adaptations that we have to make? And I'll focus on a few long-standing concepts which may undergo a change in light of how the way we work changes. Some of the panels have examined the concept of the click-wrap contracts or the standard form end-user license agreements where you only click, I accept the terms and conditions without really having any opportunity to negotiate them. And it has also been pointed out how an AI agent can possibly have a situation where this can also be negotiated. And if so, what is it? What is the implication? What is the other, what are some of the contractual concepts that come into play when there is a contract which does not have any scope for negotiation? We know of contra preferentum, the idea that if there is an ambiguous clause in a contract which has been drafted by one side and the other side has not had a chance to negotiate it, then any ambiguity in that contract would be interpreted against the party who has drafted that contract. But if the parties, if the platforms that are opening up their contracts for end-user license agreements and are opening it up for negotiations, and people also have the AI agents to negotiate their terms, and the manner in which it perhaps would be done would be by having a clause library which is indicative of this company's policies and which reflects the sort of clauses that I would want to go into any contract that I am interpreting, that I am getting into. And there is that scope for negotiation. Then perhaps would contra preferentum still apply? I think that is a question that will have to be answered by courts perhaps at some later point of time, when they will have to look into whether contra preferentum was really a question of lack of negotiation at all, or was it a question of an imbalance of power between the contracting parties. There would also be a difference in the way we look at other concepts like consensus ad idem, where we can start looking at things like consensus ad code, which we may call it perhaps, where the parties say that, okay, we are agreed on some basic concepts, but going beyond the usual variable price contracts or variable quantity contracts or algorithmic trading, we can also look at situations where a vast majority or a significant chunk of the contract will be decided by an AI, or which is mutually agreed upon, or by two AIs representing each of the parties. And in those cases, what will be the impact of it? As of now, as has been pointed out, perhaps there is no specific recognition of these things in Indian law, and as Justice Karya had pointed out, that the provisions of the Contract Act are broad enough that they can possibly be extended to include some of these things. We may also draw inspiration from the UNCITRAL model law on automated contracts that has been put out last year. Now this UNCITRAL model law, we are not strangers to the UNCITRAL system, with some significant legislations like the Information Technology Act, the Arbitration Act, Mediation Act, and the Insolvency and Bankruptcy Code being taken from there. And perhaps this is slightly different in that it doesn't set out an entirely new code, but provides some amendments that can be done. And with these things, with these sort of changes, we may look at ways to adapt to the new realities of entering into and negotiating contracts with the help of AI. Thank you all.
Thank you, Vikram. Thanks, everyone. And so just 1 minute over time. So he's done you proud, sir. Thank you.
We are honored and privileged to have amidst us the Honorable Mr. Justice Vikram Nath, and we invite him to the dais as the chair for the next session, which is on artificial intelligence and judiciary. The co-chair for this session is Honorable Mr. Justice Suraj Govindraj, Judge, Karnataka High Court. These speakers, we have a very eminent panel of speakers for this session. Mr. V. Sudhish Pai, Senior Advocate, High Court of Karnataka. Mr. Shreyas Jaisimha, Partner, Arna Law. Mr. Siddharth Sharma, General Counsel, Tata Sons. And Mr. Kirit Javali, Advocate, Supreme Court of India. We leave the floor to you.
Good evening, everyone. I am thankful to Justice Upadhyay, Chief Justice, Delhi High Court, for overriding him and taking over his session and pushing him back after my session. I have another commitment, and Ms. Tiwari's program and Mr. Ganguly's program is running late for whatever reasons. So, it's my duty to thank Justice Upadhyay for this. So, gentlemen, we have a very distinguished panel with me. A very tech-savvy judge from Bengaluru. This is Suraj Govindraj. I met him here in the same auditorium last year when I had come, and he surprised me with his tech-savvy, mischiefs that he keeps doing. Then we have Mr. Sudhish Pai, senior advocate from Bengaluru. Mr. Shreyas Jaisimha, partner Arna Law in Bengaluru. I met him while I was waiting in the lounge. Mr. Siddharth Sharma, General Counsel, Tata Sons, and Mr. Kreet Javali, advocate. So the sequence would be that each speaker will have his own time, but we have an outer limit to finish our session by 5:30, and we'll try to do it. It is a privilege and indeed a pleasure to chair this panel today as we gather under the distinguished banner of the UIA to examine one of the most consequential questions of our times. How should the judiciary engage with artificial intelligence? Let me begin with something that needs to be said plainly. Artificial intelligence is no longer a subject of science, fiction, or a distant promise on the horizon of tomorrow. It is here. It is being deployed in courtrooms, in law firms, in legal aid clinics, and in the administrative corridors of judicial systems across the world. The question before us today is not whether we will engage with AI. We are already. The question is how. It must be thoughtfully, responsibly, and on our own terms. Judicial systems the world over are confronted with a common crisis: staggering case backlogs, administrative inefficiencies, language barriers that deny equal access, delays that erode public trust, and an overburdened court staff. In India alone, the burden of pending cases runs into an overwhelming scale. If AI can help address even a fraction of this burden, it deserves our serious attention. Let us be precise about where AI offers genuine value. It is, at its best, a powerful administrative and analytical tool. It can recognize patterns by sifting through thousands of judgments to identify legal trends that no single human researcher could process in a lifetime. It can list and summarize legal precedents with speed and breadth. It can generate tables of dates, track filing timelines, and flag procedural lapses before they cause injustice. It can assist in case scheduling, an unglamorous but vital function that courts urgently need. It can power chatbots that relieve court staff from the repetitive burden of answering routine questions from self-representing litigants. Significantly, AI can break down the wall of language. India is a country of staggering linguistic diversity. The Supreme Court's judgments delivered in English remain inaccessible to the vast majority of citizens they affect. This is where SUVAS, the Supreme Court Vidhik Anuvad software, represents a genuinely transformative step. This AI-based translation system converts Supreme Court judgments into regional languages, making the law acceptable and accessible to people in their own tongue. This is not a small thing. That is the democratization of justice. Internationally, the conversation is advancing rapidly. The European Union has adopted the AI Act. Across jurisdictions from Singapore to Canada and parts of Latin America, law firms are increasingly experimenting with AI-based legal research. The e-courts project in India, now in its advanced phases, integrates AI-assisted legal translation, AI-driven legal chatbots, and predictive tools to modernize judicial functions. And yet, this is the heart of what I wish to say. We must be unflinching about what AI cannot do and what it must never be permitted to do. AI does not understand justice. It does not understand fairness. It does not understand the rule of law. It may simulate the language of these concepts with remarkable fluency. It may sound as though it does, but justice requires true understanding. It requires the capacity to weigh conscience, not just precedent. We have already seen troubling examples lawyers have submitted. AI-generated research to courts only for those citations to turn out to be entirely non-existent. Courts in several countries have had to issue guidelines specifically warning against uncritical reliance on AI-generated legal research. This is a cautionary tale. The tool can mislead, and when it misleads in a courtroom, the consequences are not merely academic. There is also the deeper problem of bias. AI systems are trained on historical data, and historical data carries historical injustice. Social biases of class, caste, race, gender, and geography are present in the data sets. An AI system used for predictive policing, for instance, may perpetuate patterns of discrimination under the disguise of neutrality. The appearance of objectivity can be more dangerous than any openly acknowledged subjectivity. Different countries operate within different moral frameworks and value systems. What is legally and ethically acceptable in one jurisdiction may be deeply problematic in another. An AI system built on data from one legal culture cannot simply be transplanted into another. The value system that must ultimately govern the use of AI must remain irreducibly human. There is another risk I want to name, one that is subtler and perhaps more insidious. Over time, familiarity with AI breeds a dangerous comfort. You begin to trust it more than you question it. You start believing more and more in its accuracy. You offload cognitively and you stop doing the work of verification, of critical scrutiny, of independent judgment. The tool which was meant to assist your thinking begins to replace it. This is a warning for all of us, may it be judges, lawyers, court administrators. Use AI by all means, but use it with sustained, deliberate distrust. Verify what it tells you, question its conclusions, treat it as a starting point, never as an end point. The moment you extend to a machine the kind of trust you place in a colleague's judgment, you have made an error. George Orwell, the English novelist, wrote, "The essence of being human is that one does not seek perfection." AI, by contrast, is designed to optimize, to converge on the most efficient answer, to pursue a kind of algorithmic perfection. But justice is not an optimization problem. It is a human endeavor, messy and imperfect, shaped by context and the irreducible complexity of human lives. That is precisely why it cannot be delegated to a machine. What then must we do? Collaboration is key between governments and civil society, between nations sharing experience across borders. AI can already connect different high courts, harmonize procedural data, and create shared repositories of legal knowledge. These are genuine opportunities, but we must insist on institutional safeguards. Data security and ethical governance are foundational prerequisites. There are constitutional questions, not merely technical ones. Let me conclude where I began. AI is here. It is a tool, a powerful, consequential, and potentially transformative tool, but a tool nonetheless. It is not a decision maker. It is not a judge. It cannot assume the moral responsibility of a judge exercises when he or she looks at a human being and a case before them in court. Our task as panel and as global legal community is to harness what AI offers, that is the efficiency, the scale, the linguistic reach, the administrative relief, while holding firmly to what it cannot provide, wisdom, empathy, accountability, and the lived understanding of what justice truly demands. I look forward to a rich and rigorous conversation with my distinguished co-chair and our eminent speakers. What I hope this panel achieves today is not a verdict on AI, but the opening of a deeper, more thoughtful conversation. I look forward to it. Thank you. So now is the tech-savvy judge, Suraj Govindraj from Bengaluru.
Good afternoon, everybody. Justice Vibhu, Judge, Supreme Court of India, Justice Upadhyaya, Chief Justice, Delhi High Court, my sister and brother judges, and my fellow panelists. I'll not name them because the mandamus has been issued for 9 minutes. So we'll try to keep it, I'll try to wind it down in 9 minutes. We have spoken from morning about AI, artificial intelligence. What is artificial intelligence? To some extent we have understood. We are at an inflection point. The technology is progressing so fast, and it is artificial intelligence was not coined yesterday. It was in the 1950s when Professor Alan Turing coined the word artificial intelligence. It took half a century to reach where it is, but from 2023, ChatGPT changed the entire thing. Sam Altman came up with this ChatGPT, he announced it to the world, and everybody knows about ChatGPT. 3 years back, when I was standing here and giving one more talk, nobody had heard of ChatGPT. We had to show people what ChatGPT was. Today, everybody knows ChatGPT, Grok, etc., etc. Now, I'll take a little different stand. Why? And do we have an option but not to go for AI? Can I ask you this question? All of you are dealing with law, all of you are dealing with courts, you're lawyers. How many cases were filed before the district judiciary from 2015 to 2025? Any guesses? We have 9 minutes, please take fast. Couple of lakhs. I think you have 2 lakh cases in your office. Any more? To cut it short, we had 15 crore 76 lakh cases which were filed across the district judiciary, both civil and criminal, across the country. Now can you guess how many of those were disposed of by the district courts? Fast. 1 crore. You have very good impression of the judiciary. Next time you appear before us, we will take care of that. And being a government advocate becomes a little more difficult. Any more? 10% of it. Mr. Senior Counsel? We disposed of 13 crore 92 lakh cases at a case clearance ratio of 88.32%. But what we have is that 12% which is accumulated, and that adds to the backlog. The other backlog is that the day a case is filed, it is treated as pending. That, sir, is something that we need to do a change, because the day, today morning, if a case was filed, it is treated as pending. There's no time limit which has been given for a case disposal. If the partition suit, should it be 2 years? For a specific performance, should it be 3 years? You fix the time, and then thereafter it becomes pending, not from the day one that it is filed. Now, in this whole thing, what has happened is we have got 4 crore 37 lakh cases pending across the district judiciary, out of which 2 crore 30 lakh cases were filed the last year. So what we have is actually 2 crore pendency, but 2 crore 30 lakhs filed last year are treated as pendency, and judiciary has said that you have 4 crore 37 lakh cases pending, and therefore judiciary becomes a punching bag. So is that the way that we need to look at? Is one part of it. The other part of it, speaking of AI, I can give you Karnataka figures also. We had nearly around 1 crore 60 lakh cases which were filed before the district judiciary. We have disposed of 1 crore 40 lakhs at 87.61. We again have 13%. This is average across the country. Now with this, the scale is real. The figures are real. We have 4 crores 37 lakhs that we have to take care of, apart from 60 lakhs in the High Court and 82,000 in the Supreme Court. Supreme Court constitutes only 0.1% of the cases which are pending. Bulk of the cases are pending before the district court at nearly 89%. These 89%, can we add a little more impetuous to it to make it more productive, to make the district judiciary more productive? And while could it be artificial intelligence which could work the wonder or the magic remedy in that? Now, we have judges of 20,000 district judges who are there, and we also have only 24 hours a day. Neither the parliament or the legislature can change that 24 hours a day, nor can we append the 20,000 judges to 30,000 judges, because we are still at 21 judges a million, when the recommendation will last 2 decades over is 50 judges a million, which has not happened. So when neither the 50 judges per million is happening, nor 24 hours cannot be increased, how do we bring in AI to increase the efficiency? The bulk of the work that many judges would agree with me, and even the lawyers would agree, is not the draft, the final draft. By the time the draft is ready, it undergoes many iterations. The first draft may be done by a junior, then it goes in, then it goes to the client, then it comes back and goes. There's a lot of time which is spent on that. Could AI help in the faster filing for a lawyer and faster disposal for the judiciary? There are a lot of administrative functions like research, transcription, in the filing stage, at the stage of defect filing and the scrutiny for the purpose of listing. There are so many other things of summarization, etc., which are there, which could add an hour or two to a judge, to the productivity of a judge during a day. If 2 hours a day is added to a judge's productivity, then probably we'll be adding around 2,000 to 3,000 judges easily to the 20,000 that we have. And if we are working at 20,000 and having 89% efficiency, if we have this 3,000 to 4,000 addition, that 11% will go away and we are at 100%. So that is what the scale of AI could be for the purpose of disposal of cases in terms of just minor aspects that could be taken care of. Normally, many of us jump to saying that when we use AI, we are looking at AI judging or AI writing the judgment. We are far off from that. The training of it has to happen. We have many judgments. If we train a judgment of 1950 which has been overruled, for example, industry definition, if tomorrow it is overruled, then what happens to all the judgments which have been rendered on that basis? That training will be of no use. Law is an evolving process. There is no stagnancy in it. Because there is no stagnancy, there cannot be a closed training module which could be developed. Medicine is different, engineering is different because there's a closed module. But in law is a social, we are social doctors. So anything that is evolving cannot be trained and put into a straitjacket formula. So that straitjacket formula would be very difficult to achieve. But we can move closer to it. So if we move closer to it, that efficiency is what we can speed up the structure, which will probably reduce the stock. Now, efficiency versus constitutional integrity, many of us spoke, Justice Vikramnath just spoke about it, is that it should be only in the administrative work of the in a judicial day, not in the judicial work, because judicial work requires a different frame of mind. A lawyer also needs a different frame of mind to argue a particular matter. He would argue a motor vehicle accident differently than a check bounce matter. So the way that a case is presented would be different. The case that has to be dealt with by a judge would be different. So the topic is artificial intelligence and judiciary. It is like that agreement of sale and agreement for sale. It is not artificial intelligence in judiciary, it is unjudiciary. So unjudiciary, when we speak of, these are the things which would have to come about for us to think of. And this would necessarily involve a robust innovation mechanism with a much more robust governance mechanism, which we spoke of. We need a proper guardrail governance mechanism so that this can be taken care of in a proper manner. Access to justice, that was also spoken of as to whether this will give rise to access to justice. We are, in my opinion, sir, we are looking at docket explosion is what we are saying today. But the way that the filing has been, we are looking, for example, in the district judiciary, we had an institution of nearly around 1 crore 53 lakhs in 2018. Today we are at 2 crore 47 per year, and it is only bound to increase. But with the legal literacy which is happening and the regular literacy which is happening, this is even bound to increase. We are not, we are looking now at docket exclusion, not docket explosion. And that docket exclusion, when it becomes an explosion, we are probably looking at 5 to 6 crores of cases being filed. For example, in Karnataka, we have 1,45,000 judges, for lawyers, for 1,050 judges. So imagine the number of filing which will happen, and that will be the docket exclusion to docket explosion as a thought process. And that is why artificial intelligence and judiciary, we need to look at both, all the stakeholders, the lawyers, the judges, the support staff. If each of them can become more and more productive, and we can use these stakeholders to achieve a better input, that is what the final stakeholder, who is the litigant, will get a result out of. Thank you.
Thank you, brother. We now have Mrs. V. Sudhesh Pai senior advocate from High Court of Karnataka. You could speak from here if you like.
No, no, it's fine, no problem.
All right.
Honorable dignitaries on the dais and off the dais, friends, we are almost at the end of the day and I would not take more than 5 minutes.
Thank you so much. Yes.
Artificial intelligence has come to stay. The question is not whether we should use it. The question, I think everyone is agreed, is how to use it, how to manage it. It may almost be described as Proteus, the Greek god, who takes many forms. The rise of artificial intelligence in the field of law has brought both innovative solutions and complex challenges. It plays a calibrated role. The question is, what is that role? Just as Vikram Rath pointed out, just as Suraj Govindraj pointed out, the role is essentially limited to administrative work in the judiciary and not to adjudication as such. The application of artificial intelligence brings about greater efficiency, and this enhancement of efficiency provides both judges and lawyers more time to focus on something more essential. AI is only supportive. It cannot replace or supplant the human factor. However much a machine may work, artificial intelligence may serve us, I think the nuances that a human brain and a human personality are capable of can never be underestimated or forgotten. Judicial decision making entails sophisticated fact interpretation, credibility assessments, balancing opposing rights. All these are perhaps beyond data processing. The judiciary has adapted the use of tools in a safe and accountable manner, which strengthens the court's efficiency and safeguards keeps institutional safeguards in place. The Supreme Court E-Committee, reconstituted last year, has endeavored to tell us what it is. The white paper that came in November 2025 reflects the approach which balances between innovation and institutional integrity. It is an acknowledgement that adjudication is a constitutional responsibility based on human judgment, ethical reasoning, and contextual interpretation. We have all spoken of, and we all know that AI now generates decisions, but many of them are what is called hallucination or fake precedents, which can be extremely dangerous. And in the process, I'm afraid we are not saving time, we are spending more time to verify whether the AI-generated decisions are correct, whether they are real, and whether the ratio that is presented is really a ratio or some passing observation. I think this is one area which all of us have to be on our guard. I'm afraid this is always so in anything when we rely upon too much of mechanical support. I think when we were young, we didn't have computers at the click of a mouse to get a decision. we turned the pages of volumes, the original commentaries as well as the judgments. The advantage, if I may say so with respect, is that today's click of the mouse gives you an immediate solution for the present problem. But reading commentaries and judgments in the original helps you not just with the problem on hand, but you equip yourself better. It increases your learning, it widens your horizon, it enhances your wisdom, and whatever we have gained comes in aid at some point of time or the other, maybe in a faraway future, but that is always more beneficial, more sound, and something that we cannot overlook. The same could be said with artificial intelligence also, because ultimately it is the human factor, the human mind, the human personality that counts. Particularly in constitutional courts, you can't decide the constitutionality of something by pressing a button. The factors that go into it are so many. And the judge's outlook, the judge's ideology, the mores of the day, all these essentially get into the calculus of adjudication of constitutionality. And that is an area which I think is essentially human. It can never be, I know it's never delegated, but even the help that one could get from artificial intelligence in these areas would be minimal. And I think we would be better advised not to look to artificial intelligence for such areas, because the precedents that they give cannot answer these various nuanced situations. There is also, even in the administrative side, the priority for posting. When fundamental rights are engaged, habeas corpus petitions, the priority that these cases would have to get stand on a different footing. Now, of course, we have the UNESCO guidelines and the European Union guidelines. I'm sure Shreyas will touch upon it when he talks about the comparative perspective. The most enduring function of the rule of law is maintaining institutional confidence, which allows innovation without surrendering stability. Innovation will have to be grounded in fairness, accountability, and social purpose. The litmus test, I believe, is that the use of artificial intelligence must ensure the litigant, they should feel assured that cases are heard promptly and decided fairly. This goes to strengthen the rule of law. And this is the ultimate to which all of us must aim. The litigants for whom the courts are meant should not turn their faces away from disillusionment for fear that justice is a will o' the wisp. Ultimately, justice has to prevail, justice dispensation. Thank you so much for your patience and courtesy.
Thank you, Mr. Pai. So now we have Mr. Shreyas Jasimar, partner, Arna Law, Bengaluru. You have 5 minutes, sir.
Dignitaries, allow me to please commence my address immediately. I want to observe that India has been one of the founding members of UNCITRAL. This year marks the 60th year, 60, of UNCITRAL. If you look at India's participation in international law making as opposed to law implementation, you will find that we have been excellent at adopting conventions, model laws that have been framed internationally, but in the participation of the creation of those very norms, our voice, though we're entitled to exercise it, has largely been silent. This silence should not haunt us in this moment. And therefore, my few minutes are really a call to action to every creative mind, judicial, legal and beyond, and there are also technologists in this room, there are engineers who are sitting in this room, to seize this moment. Carpe diem. We have to be manufacturers of norms, not merely recipients of code. Code in both senses. Code as algorithm and code as law itself. And here, therefore, we have, unlike many other civilizations, we have very deep civilizational roots to look at. I'm not saying be parochial, I'm not saying be exclusionary, look only there and not elsewhere. But please, if we don't look at Mimamsa, if we don't look at Pramana Shastra, if we don't understand what is the idea of determining it through discourse analysis, what is considered authentic to its source, we have an entire body of knowledge that is available to us. This body has to now be transformed into actionable language models. We have Sarvam AI, we have BharatGen that is working. This is all insufficient. We have the number of languages that we have is far more than the 18 that the judgments have been translated into. We have thousands of languages. Many of our languages of yore, not just Sanskrit. There is languages of South India like Mani Prabhala. There are languages of yore, even Prakrit. There is a store of knowledge that is kept in these places. And therefore, I would say, if I look at my international review, the one thing that stands out, be it the Compass system in the United States, be it the experiments that have been taking place in Canada, in Colombia, in Argentina. One thing, I will not spare you the details of it, Singapore and China. One thing that stands out is most of these experiments are state-owned experiments. And now contrast that, if you may, with the free-for-all systems that are observed in other parts of the world. Lawyers don't own the architecture of a building, of a court. But is that what we are seeing when it comes to digital architecture? Is this what we are seeing when it comes to the number of the various entities? In fact, even for this very seminar, many of them were invited. What we are seeing with technology is there is largely a duopoly that is emerging as a pattern. You look at door-to-door delivery. You look at, in fact, the two biggest entities offering legal AI solutions. I don't need to name them. But there is always a system where two tend to emerge. And this is a dynamic that is also true of AI. So unless we look and dig deep, we are not going to go anywhere else but to land at a space where we will find that there is the world's best legal AI touts itself as being valued at $11 billion. The next best says it is valued at $8 billion. All the Indian players are saying they're already outgunned. They're nearly ready to surrender. So the reality is that we'll be left with two American choices, like we have with Coca-Cola and Pepsi. And even Thumbs Up isn't bought over. This is the scenario that we're likely to find with AI solutions here, unless we dig far deeper into merely implementation ideas and rather look at the production and ownership and control of the AI systems itself. And there I think India already has excellent examples through its digital public ownership of, be it Aadhaar, be it several other systems that we have developed. And the final point I wish to make is that prompt engineering is a topic we have not touched upon all day. I don't need to say more than those words again. Prompt engineering is limited by your vocabulary. So just at the time when people have stopped reading, just when their attention spans have dropped, just when focus has dropped, the most powerful skill remains focus, concentration, and vocabulary. Prompting is a useless skill with zero vocabulary. And therefore, you cannot mirror AI with an untrained driver or a person next to it is going to produce disaster. It is not going to produce great knowledge. And therefore, along with the AI ownership and control, we need a deep literacy program that really allows us to create our vocabulary once more. And surely that vocabulary should not be limited by English. Thank you.
Thank you, Shreyas. I now request Mr. Siddharth Sharma, General Counsel, Tata Sons, to. I hope you are conscious of the time. So yes. That's a request, yes. No, not by me, but by the organizers. Yes.
Yeah, thank you, sir. Thank you. next week the new IPL season is going to start in this city itself. So I think in the keeping with that spirit, Justice Nath's directive to all of us is very relevant. We have to bat like 2020. Thank you very much. It's an honor to be here, and thank you for the opportunity. The topic is a big canvas, AI and judiciary. Much can be said on this, but as a general counsel, earlier I was a practitioner, but now as a general counsel, I would just very quickly share my views and break it down in three subtopics. One, can we use AI in the judiciary to make the overburdened system more efficient and predictable? And when I say predictable, I don't mean predictability in outcome. As they say, justice discriminates on the basis of merit. So as a litigant or as a consumer of the judicial process, when I say predictability, what I mean is that can we use technology and the boon of AI, if we can say so, or the advantages of AI, to make or to get rid of the double whammy that the system currently suffers from. Today, the judicial process is not only delayed, but it is also unpredictable. As a litigant, given Justice Govindraj just gave some data points on the pendency of cases, as a litigant, if I file a case today, I don't expect my case to be heard next month and finally disposed of. If I know that my case will be heard 3 years from now, that is fine. But 3 years from now, when the case is heard, can I be assured that a hearing will take place? And that is where I feel that the case management, listing of cases, sorting of cases, checking conflicts, giving alert, I think AI tools offer a huge opportunity, and that our judiciary must use. Secondly, whenever we, of course, one of the things that we often find in court is that your case is listed and you are told somebody is mentioning the matter, somebody is seeking a passover, and because the case management has gone haywire, can the AI tool tell the registry that don't list this case because you have 5 other heavy matters before this case? And therefore, to bring in efficiency, I feel that AI offers great opportunity. Second is about use of AI as a tool for information, for analysis, and for empowerment. Empowerment both of the lawyers and the litigants. I'm sure AI tools offer great deal of access to information. Lawyers in smaller towns, lawyers with not so much of financial backing can access information, worldwide information on a click of a button. That of course is very empowering. Likewise for litigants. Litigants can make informed decision using AI tools. AI tools can give data set. AI tools can give past historical data, and that can also influence decision making, not how to fight the case, but whether to fight the case. And that, as a general counsel, I feel that AI tools can be very helpful. Access to resources, informed decision making, simplification of complex legal problems, I think these are all the big advantages that AI offers. For the institution of judiciary, I feel AI really gives you the data to analyze the institution well and take steps, actionable steps for reform. Case trends, backlog patterns, types of disputes, and allocation of resources. All these policy making can be done in far better way through the analysis and data set that AI can offer. And the third head of my, when I share my views, now I come to the point about use of AI in decision making. Now, of course, recently I read somewhere, and if I'm right, I think it was said by Daniel, I forget the name, he's a serial entrepreneur. he said that a US entrepreneur on a podcast that plumbers will last longer than lawyers, and that is the disruptive prediction of AI. What he meant was that going forward, perhaps plumbers will make more money. Some of the jobs that lawyers are doing may not be required. AI tools will do those jobs. Now, obviously that is one extreme, and as far as if I have to share my views personally, what I feel is that AI is a big tool in the hands of the judiciary, but it cannot do the judging. Of course, there also you can break it up in various parts, say 138 cases, motor vehicles claim compensation cases, income tax assessment appeals, where data set, where the outcomes can be more predictable, where you can have, where you don't deal with complex legal issues all the time, and therefore to make those decision making, AI can help. But as it was pointed out by Mr. Pai, that in constitutional cases, can you apply AI? The writ courts, every day they decide, they sit and review administrative decisions for non-application of mine. I only wonder if a court uses AI tool to decide on a question of non-application of mine. How do you interpret these basic concepts of justice where application of mind, how will you read application of mind when AI is applying the mind and not the judge or the counsel? Likewise, we've already know, this has been written about a lot, black box problems, how AI is reaching its conclusion, that is not transparent. The data set that it is using, the logic that it is applying, and therefore, if judgments are being written using AI tools, of course, the question of accountability and transparency comes. AI tools tend to give standardized answer, but a judgment need not follow a template, and therefore, that is not something desirable. Appeal, our institution of judiciary is based on hierarchy of courts. You know that if a trial court can get it wrong, the High Court can correct it, then you have Supreme Court. Now it's not perfect. Nobody says that what Supreme Court will do will always be the perfect justice. But you have the system of checks and balances, and if AI is being used, then how do you bring in that checks and balances? Because what the court of first instance is using, the appeal court is also using the same thing, and AI tool may prompt the same result, and therefore the whole concept of appeal or the transparency in appeal becomes questionable. Lastly, judging is not about uniformity. Judging depends on context, intent, social realities, moral reasoning, and in the end, human judgment. I only wonder that whether AI could write a judgment like Yeshwananda Bharti, whether AI could develop the basic structure doctrine. The whole case was not all about precedents. If you see, the precedents were against the basic structure doctrine, but still the passionate advocacy of Mr. Palkiwala and the instinct of Justice H.R. Khanna, personal instinct, gave us the basic structure doctrine. When the review bench was set up, again, Mr. Palkiwala argued, and what Justice H.R. Khanna later wrote, that day Nani did not speak, divinity spoke through Nani. So in constitutional cases, I think this fear that AI will replace human instinct, I think that is overstated. I think there will always be a place for thinking lawyers and thinking and humane judges. In the end, I will just conclude that AI is a transformative infrastructure. It's a remarkable enabler, and it's a great tool that brings convenience. But can it build jurisprudence? Can it show compassion? And can it keep a question open? In many cases, we see the Supreme Court says that we are not deciding this case. We are leaving this question open. Whereas AI will always try to decide something. Why? Because that is the human experience. And I just say, as they say, it's a cliche, that the life of law has not been logic, and AI is all about logic. Life of law has been experienced, and I think that that experience will always count. Thank you very much.
Thank you, Siddharth. I now request Mr. Kirish Javali, advocate, to.
Honorable judges on the dais, senior colleagues, honorable judges of the dais. I understand a lot has been said throughout the day on AI and how it's been an administrative tool, and many important aspects have been deliberated. I think India today stands at a critical juncture. On one hand, we are one of the fastest growing digital economies in the world. On the other hand, our judicial system is burdened with severe backlog of cases. At the heart of the system lies the trial courts. I will be talking primarily in the trial courts, the courts of first instance where facts are tested, evidence is recorded, and rights are determined. I think access to justice is where the nub of the matter is, and which has been the issue for many years. It entails a person's ability to seek a legal remedy through different systems of justice, either formal or through informal or ineffective or cost-efficient manner. Within the framework of the system, there remains a persistent challenge, even with the constitutional guarantee of equal protection of the law under Article 14 and under Article 39, access to justice is timely and meaningful. It is in this regard that technology has increasingly been viewed as a possible leveler. The application of technology, in particular AI, within the justice system is no longer a futuristic possibility, but it is already here. I think, as we all heard throughout the day, it is not a judge, but it is basically a machine which can be fed in with data and patterns, but ultimately you need the human empathy and how cases should be decided over a period of time. India's judiciary leverages AI and the different e-courts program, right from 2005 onwards, then more recently through the Supreme Court mechanisms, SUES and SUPES, and then more recently the Kerala High Court came up with a very interesting policy, where it's the first of its kind in which any High Court came out. It said the Kerala High Court's policy on the use of artificial intelligence tools in the district judiciary was issued on July 19, 2025 and marked as the first High Court in India to establish a formal binding framework restricting AI's role to assistive functions only. It prohibited its use for judicial reasoning, findings, orders, or judgments, while mandating human oversight. Applicable to all district judges, staff, interns, and law clerks, the Kerala policy emphasizes transparency, fairness, accountability, and confidentiality, barring cloud-based tools like ChatGPT to protect data privacy under Digital Personal Data Protection Act 2023, and requiring verification of AI inputs and outputs to counter hallucinations and automation bias. So, in essence, we do need a unified national framework rather than having different high courts coming out on their own policies and standardization. So we will require ethical auditing, judicial training, and infrastructure. And I think the lawyers also need to be educated how to responsibly use AI, because I think in the trial courts, different levels of lawyers are there as across in the High Court or Supreme Court. That education and awareness equally is important. And that is where we lack training. And I think that, and how lawyers also are misusing AI and not really thinking. Reading has not really diluted completely. And as there was an article recently in the Times of India, are we raising the bar or lowering the bar? And I think that definitely we are lowering the bar. We need to be more responsible how to use AI. Thank you so much.
Thank you, great. So, thank you everyone for patient, listening to all of us. And we close immediately and the next session can start. Justice Upadhyay, you're welcome. Thank you.
Chandani, Linklaters LLP Singapore, Mr. Ravi Singh, Senior Advocate and Deputy Director General UIA, Ms. Geetu Singh, Partner KPMG India, and Ms. Purnima Hatti, Founding Partner Samvad Partners Bengaluru. Thank you.
I must thank the organizers of this conference and discussions. Why did I readily agree to prepone Justice Vikramnath's session? Rather, I welcomed him and I invited him. Because had he been here, my task would have been a bit difficult. So, as I understand, the topic to be discussed in this session primarily focuses on ADRs. In the previous sessions, many speakers expressed certain reservations about use of AI in decision-making process. But so far as the ADRs are concerned, they are not the decision-making processes in the traditional sense of the word. So AI needs to be used in ADRs. That's the first consensus, perhaps. Some of the issues I would flag before the discussion formally takes place. Now, one use of the AI which can be put to use in the ADRs and which comes to my mind is that, we have all tried mediation, but there is a process which is akin to mediation, which is called early neutral evaluation process. This is yet to be introduced in the country. This is process, as I said, is akin to the mediation process. Once the mediation fails, now the neutral evaluators are appointed. They interact with the parties to a dispute, and they make their neutral assessment of the strength and weaknesses of the cases of the respective parties, and then they tell the parties that these are your weaknesses, these are your strengths ultimately. So this sometimes, rather many times, may result in immediate resolution of the dispute. So here this neutral assessment, evaluation of the strengths and weaknesses of the respective cases of the parties can be entrusted to AI, because the AI ultimately is neutral. So this is one area which can be AI, where AI can be put use to in the ADRs. Another aspect which I wanted to highlight is that since morning we have been listening to all the discourses and discussions, but dispute in the society does not arise only in the realm of contracts or commercial disputes or in the business or the corporate dispute. There are various other areas of disputes where what use AI can be put to, that also needs to be thought over. Then, of course, the issue relating to digital divide. Now, we have all been talking about use of AI, but considering the kind of diversity which our society, our country has, this digital divide, even in the use of AI, will not act as an impediment to have the right to access to justice. This also needs to be thought about by all who are associated with this kind of discourse. So with these initial comments, I would invite Brother Justice Krishna Kumar.
Good evening. I think it's a real late evening now. This Honorable Justice Upadhyaya, brother judges, sister judges, ladies and gentlemen. Justice Upadhyaya has already flagged the broad aspects of what we need to discuss in this session. The rest of the discourses have already been, all of you have heard. I would only like to flag, rather reiterate the very same thing. Without getting into details, my co-panelists would probably do that. The first one, as all of us know, is usage of AI in dispute prevention. Now, as all of us know, large commercial entities today use AI-driven contract analysis tools that can flag ambiguous clauses, inconsistent obligations, or high-risk provisions at the drafting stage itself. What traditionally required days of manual review can now be done in minutes. This does not merely save time, it reduces probability of disputes arising from poor drafting, which is probably the most efficient form of dispute resolution. The second thing is early case assessment and predictive tools that Honorable Justice Upadhyay has already spoken about. Then the third aspect would be AI-assisted mediation, which again is an important development which I think AI can be used very usefully for the purpose of solving, or rather this mediation drive which has recently been started by Honorable Justice SURYA. I don't know how much of AI has gone into the dispute resolution in this mediation drive, but it's one area which all of us can really work towards. Then online dispute resolution is yet another area. Then we are talking about AI in legal research and case preparation. And then while we recognize these advantages, we can't again ignore the concerns that accompany them. Questions of reliability, transparency, and bias remain very real. Now, even this, all of you have heard throughout the day. An algorithm is only as good as the data it's trained on. As Shreyas said, the person prompting is the person, the result is only as good as the input that goes into what the AI gets. And then this again is one more area of concern which all of us have flagged. So with this, I think I'll hand it over to my co-panelists to take it forward.
So we'll just make it brief. I think you've all been very patient, and I appreciate everybody's still being here to hear us on this. Let me start by thanking UIA for the opportunity, of course, and the honorable judges on the dais and off it. So I just wanted to address it in a slightly different way, using some examples on the issue of, what is decision making, even in alternative, what are some of the tools that are being proffered, and while in, of course, ADR, which is mediation, as well as in arbitration, the issue comes up in what is the predictive mechanisms that current generative AI can offer. Now, generative AI is sometimes, the distinction is with algorithms. It is not an algorithm. It is generative from machine learning, whether closed loop or open large language models, which brings it to what has been referred to sometimes as hallucinations, which is deliberate falsehoods, which are given by AI systems, much to the prejudice to lawyers who have tried to short circuit. And in fact, now, at least in the UK, there is bar standards which require lawyers to give affidavits while filing written submissions, that if they've used any artificial intelligence tools, those have been verified, citations have been verified, facts have been verified, so the ultimate professional responsibility then comes to the lawyers. There was one case in which 18 out of 41 of the citations which led to these were in fact incorrect and wrongly relied upon. So this is where, these are things which the Honorable Supreme Court is also considering in this country, is what we lawyers will be able to give in terms of support. Now, hallucination, we are debating whether AI can replicate humans, but I don't really know any other species except maybe pets looking for a treat which lie deliberately. So if AI is lying deliberately, which is what hallucination is, then we have some human-like conduct already by generative AI which is being offered. And so what does generative AI help with in terms of, and what is the dangers in terms of predictive analysis? There is a case called State of Wisconsin versus Loomis, in which, this is not of course in ADR, but it offers a illustration where the issue of Compass, which was a software which is used to analyze recidivism, whether those accused of crimes would commit them again, as a determination of sentencing was challenged. And it was held to be relevant with the caution to juries that it is proprietary, that it is based on group data, research indicating that it may disproportionately classify minority offenders as high risk, and the lack of specific validation study for the Wisconsin population as a whole. So this is a tool very much which was saying whether a person who was going to be convicted would commit a crime again. These sort of predictions are also being used within other jurisdictions. Brazil is starting to use it, but also within our jurisdiction. So one of the tools which we are all subject to, whether we are lawyers or on the judicial end of things, is the income tax faceless assessment, which is using predictive patterns of all the data which is going into the financial intelligence units to predict whether a survey should be done, whether reassessment. In fact, the Honorable High Court of Madras, as well as many of the ITAT branches, have been looking at this issue on whether it can be relied on alone. Because again, it is based solely on data, but the algorithms that it's using, or what is the predictive ability, cannot be questioned and is not always even known in what is the data being pushed up. So should that lead in and itself to reassessment? As we all know, reassessment is not a wholly neutral project. So once reassessment starts, even in faceless assessment, there can be consequences of this, and there are safeguards built into the Act to prevent against reassessment without cause. So is generative AI predictability sufficient cause or not? SEBI has recently implemented a system called Sudarshan for making a predictive analysis for issuing an initial notice on complaints onto the online system. Again, this is use of predictive AI to determine. Now, it could be it's SEBI, but again, there are actual consequences to this. So these are the sort of things which are leading to the questioning of, and the question that we must also answer, that what are, as another panelist had put earlier, what are the guardrails and what are the protections we can use and what are the efficiencies offered. As was said this morning by Justice Suryakant, in the end, a determination or anything predictive, whether it's by an arbitrator or a mediator, can only use the tools. What goes into a decision-making pattern is equity. And equity, in my respectful opinion, can never be predictable by any machine learning because it is an essentially human element. Whether equity has efficiency or compassion or empathy, which is why even in the old days in the English courts, there was rules of courts of law and courts of equity. And courts of equity was always the king or the queen's justice. Here we've of course combined it, and we have equity in the courts, which we always do appeal to as counsels appearing before the courts. So this is a question which remains, and as we look at the determination of in mediation of fact-finding, the question will remain is what credence do we give it, and how do we ensure that that determination always has a human element? While I was looking at this question, we are of course concerned with, and I'll go back to something which came up from Justice Bambani, which is that, children learn from the dinner table conversations. But here AI is looking into our deepest thoughts, even in the bedroom of the parents, and spying on every thought and conversation we have. Who do we search, etc. So this question then, is always where is the privacy, etc. On that note, what you were talking about spying, what I was talking about spying, I've had clients come to me in PMLA cases where they've put in the entire ED complaint into ChatGPT and come up with a list of advice that they want to come and ask as advice from counsel. And the first question you look is, have you just made public your entire complaint? Because anything put into AI is now available to everybody, including investigative agencies. So there is all kinds of issues in privacy, etc. But coming back to it, when we're looking at predictability, when we're looking at what is being learned, the thought I would leave it, at least according to people who study this, neurologists, etc., what is mapped today in terms of how the brain functions is approximately 2 to 5%. What is online is only one version of every human being, one part of our thoughts, our activities. So if that forms a sum total of what a machine learns to predict what a human being is doing, that is a very small subset of what that human being existence is. So it is by itself a biased perspective because it is statistically biased. It is not sufficient to predict. And that is where, whether it's from income tax or in the use of what is recidivism or in negotiations, we have to have very careful look at what is the data being presented, because in the end, whatever data is being presented, we have a bias to treat computer-generated data as, in fact, true in fact. Thank you very much.
Thank you, Avi. As you mentioned about the practice in England inviting affidavits from the lawyers, I read somewhere about, say, a month ago that some lawyers have been charged for misconduct tolls, for putting AI to misuse. And what we understand that the algorithm-based AIs, they do not pose any threat. They are easy to be supervised by the human minds. The danger perhaps comes from the machine learning tools. I mean, they keep on learning, they keep on making them more intelligent. So danger perhaps emanates from there. May I request the next speaker, Divya, you'll speak. Apart from speaking on the topic, may I request you to share your experiences in Singapore also? Thank you.
Good evening, everyone, and thank you very much, Judge and the organizers, for this opportunity. As Sir mentioned, I'm currently working in Singapore, and I thought it would be helpful to share how AI is being integrated into the court functions and dispute resolution practice in Singapore currently. It also makes my job easier because I'm sitting in the company of esteemed judges and practitioners in India who are very well versed with the practices and guidelines in India already. So in Singapore, given that it's a service providing nation, the national AI strategy of Singapore, which was ruled out in 2023, makes it very clear that integration of artificial intelligence across sectors is vital to make sure that the nation and the service providers continue to remain efficient on a global level. And in line with that, Singapore has been investing heavily to make sure that the country has the infrastructure as well as the training provided across sectors to make sure that artificial intelligence is being used responsibly. In the legal sector, earlier this month, the Law Minister of Singapore in a speech said that, and reassuringly so, that I do not think artificial intelligence will replace human lawyers, not at least in the foreseeable future, but the humans that adopt and use AI will definitely replace the humans that do not. In line with that, the Singapore courts and the Ministry of Law have rolled out 2 guidelines. One of them is the use of AI for court users, which governs the use of AI for submissions that are made in court by legal practitioners. And the other guideline is for the use of AI across the entire broad legal sector, which could be by in-house counsels, legal practitioners, legal secretaries, and everybody else. Both the guidelines make very clear that there is no prohibition on the use of AI. However, it is very important for the practitioners to take full responsibility of the output that is submitted in tribunals as well as courtrooms. It is important for them to verify the accuracy and the relevance of each submission made. And it is also important for them to ensure that no intellectual property is being infringed upon while citing any material that AI has provided to them. Singapore has also been very strict in enforcing these guidelines and making sure that no breach is taken, less seriously. So there are 2 reported cases in the last 1 year where lawyers made submissions that cited fictitious cases that did not exist at all. And in addition to imposing personal costs on the lawyers, in one case, the court also requested the lawyer to share a copy of that order and the penalty imposed with the client to make sure that the lawyers and the clients are aware of the consequences of using AI irresponsibly. Coming to the use of AI in court functions and decision making, Singapore courts have not really used AI for drafting decisions yet, but AI is being used to enhance the efficiency and speed of courtrooms. In the small court tribunal, small cases claims tribunal in Singapore, which looks at cases up to a value of 30,000 Singapore dollars, which is about 20 lakh Indian rupees. A memorandum of understanding has been signed with Harvey AI, which is a US platform, to accept the use of Harvey for summarizing cases, summarizing issues, and also assisting the clients in preparing written submissions and making their arguments. This is also because in the small claims tribunal, no lawyers are permitted to practice. All clients represent themselves, and therefore for people who lack legal knowledge, AI of course can help immensely more. Having said that, the same guidelines of verification, accuracy, and IP infringement of course apply to each submission made. Lastly, while we were discussing amongst our panelists, a practical question of how AI is changing the practice of a dispute resolution practitioner on a day-to-day basis also came up. I would say that, and I was reading about a legal study that the Harvard Law School conducted just last month, which said that AI can be used to reduce the hours of an associate from 16 hours to about 3 to 4 minutes. I tend to agree, because when I started practice, I have spent hours and sometimes days going across boxes of documents and merely preparing a list of dates to help summarize the facts of a case and, putting them under each issue that might probably come up when we come to the drafting of the claims or a response. That job, ironically, last month, when I was dumped with about 850 emails by the opposing counsel, was done for me in 15 minutes, of which 8 minutes were taken only to upload the files. And I got a tabular review of all 850 emails with the date, a short summary, sender, receiver, in I think 5 to 6 minutes. That automation of, I would say, monotonous tasks, it's a great gift because it saves time. Sadly, that does mean that the firms have to compromise on their billable hours, but that does mean that young lawyers like us can use our time more judiciously and help in assisting with legal research and legal submissions and drafting more than just the tasks which earlier used to take days, nights, hours. Lastly, I also need to caution you about the use of AI in our day-to-day practice, because my last use case that was just last week was I had to interpret a contract's limitation clause. There were 2 limitation clauses in the contract, one being a generic limitation clause and the other one being a limitation clause specific to delay claims that arise under the contract. We had prepared an advice, but just to tickle my mind, I decided to upload it on AI and also ask how would they interpret the limitation claims and under a delay clause in the contract. And it only gave me an interpretation based on the generic clause. It completely ignored the subclause which was under the delay clause for limitation. And then I asked another question to say, but what about the subclause, which also gives me another limitation, which contradicts the generic limitation in the contract. And I realized that AI is very good at stroking a lawyer's ego, because its response was, and I quote, "Thank you for this razor-sharp observation. I must say that your observation cuts right through the answer that I provided above." Great for me, but a great lesson as well, because it tells us how careful lawyers have to be to not blindly rely on AI for just contract analysis, contract interpretation, and opinions. And like I mentioned at the beginning, also reassuring to say that AI will not be replacing lawyers, at least in the foreseeable future, because if it continues to just go over clauses which are relevant, makes it easy to say that our jobs remain relevant. So that's all, and thank you.
Yes, Purnimaji, please. I understand you're associated with this organization, Samvad. It has something to do with the mediation?
Thank you, sir. No, sir. It's a law firm based in Bangalore, although the name is meant to be communication. So, but while we do practice mediation, it's not associated with any.
So we would like you to share your experiences if you have ever used the AI in your work there.
Thank you. So I will start and take only a few minutes because I know Geetu also has a flight to catch. So just starting with mediation and arbitration, which are focus areas for me particularly, I'm going to start by just quoting a few statistics from the Whiten Case and Queen Mary survey that happens every 4 years, and the last survey was in June 2025. Out of more than 3,000 people across the world who were polled, including arbitral institutions, general counsel, advocates, practitioners, 91% said that respondents expected to use AI for research and data analytics. They also said that the principal obstacles for use of AI in international arbitrations were about errors and bias, confidentiality risks, lack of experience, and regulatory gaps. The principal drivers of AI in international arbitrations were saving party and counsel bias, which was 51%, and cost reduction, 44%. Divya also just touched about cost reduction. While law firms may view cost reduction as a step back, but I think clients and general counsel will look at it as a positive way forward and connects to what Justice Upadhyay just said about bridging the gap. So with better use of AI in ADR, then we're also making sure it's accessible. Coming to mediation, we now have the IBA guidelines on mediation. The IBA guidelines specifically talk about 3 sets. In the institution, which is providing mediation, the parties that are mediating, as well as the mediator. By using AI tools, a mediator can actually suggest the kind of questions that parties should come up to ensure that that is amenable to mediation. Sometimes asking the wrong question may mean that the mediation is not possible or may not go forward. It also looks at giving different options in terms of positions and interests. Those of us who do mediate and sit as mediators will understand a lot of the movement in the mediation can be based on who the mediator is and what kind of options, positions, and interest evaluations that happen through the course of that mediation. So AI can definitely help generate individually for each party in terms of what these options are, what these positions are, and how that movement can take place. And ultimately, the mediator can then look at all of this and then come up with different perspectives on how to move forward. The mediation institution itself, let's say if the Bangalore Mediation Center begins to use mediation and AI together on an everyday basis, then scheduling of these cases, how mediators can be trained and looking at AI to help generate different options across, that would be very, very useful. I'm going to touch a little bit on what from the beginning this morning from the Honorable Chief Justice of India right to Justice Joshi, who kept talking about ultimately the LLMs will train and respond to the data that is fed. So while we begin to experiment with mediation, we should look at how our own systems are feeding in data. Our e-courts websites have been up and around for more than 10 years at least now. So what kind of data is already existing? Research just shows, for example, if it says a case is disposed of, does it mean in a criminal case that a certain criminal has been convicted? Has the person been acquitted? Have damages been allowed? So who's feeding in what kind of data? And is that case summary being reviewed? What kind of review is it? So when data is being read through these models, then only can we rely on the actual outcome. Lastly, the CIAB guidelines on arbitration also talk about disclosure. So if an arbitrator is using AI, then the arbitrator must disclose that he or she is using AI. parties are using AI, then a procedural order right at the beginning of the arbitration should document the usage of AI by everybody, so that we're all aware of what we are using, to what extent is it allowed, and where should we draw that line. So I think I'll stop here, and happy to take questions post the discussion. Thank you, sir.
So I think as the last speaker on the panel, I firstly promised to keep it extremely short too. I have to say that I am the odd one out, since I'm the only non-lawyer sitting on this panel. As a chartered accountant and a practicing forensic practitioner and a damages expert who's been testifying in domestic and international arbitrations for over 25 years now, what I can tell you is that the community of experts is from as far as my start of my career goes back to 1990s. I can tell you the collaborative partnership between experts and technology has always been extremely thick. We as damages experts and quantum specialists are always known to be able to, analyze a lot of volumes of data and complex data sets, massive documentary evidences which are put forth in front of us for us to form any business, financial, commercial or any technical opinions. I can tell you every day of the professional work we carry out, there has always been extensive use of technology. So the question which we are often asked is that, is it that AI is a friend, or is it that we are feeling threatened of AI? What stands apart about AI is that in the journey we've had with the world of technology and all the technology tools that have been used widely, AI comes as a much more complex layer. I think in that entire hierarchy of technology, AI also comes as much more powerful than any other technology tool we've seen. And the threat somewhere lies, and I say it on behalf of the community of experts because we keep debating on it every day on this, is that I think something that's different about AI is that as much as it is powerful, it brings with it a lot of vulnerability and threat to take away the control from an expert. So, if you just sort of do not pay enough attention, or there's a risk of oversight, AI can take over the expert. And I think that is actually a disaster for whatever outcome of the opinion that will come from that expert. Coming to AI, just to put it into context, I have to say that AI is being widely used already by experts. We are known for very, very deep analysis of both data as well as evidences. If I look at the whole scenario of financial modeling, damages quantification, whether it is forensic accounting, wherever we have to detect patterns and anomaly spotting and red flags, etc., whether all the comprehensive construction delay analysis, which is becoming extremely common in the whole business community and in the universe of commercial disputes, whether it is to do with the competition analysis, or let's say it's any technical failure or causation analysis. Experts are already using a very, very thick blend of both technology as well as a layer of AI on top of it. We've had very, very mixed experiences. I think what really stands out is that what AI has done is that where technology was definitely helping us bring much more accuracy, speed and scale to the analysis that we do, AI, of course, has stood out to facilitate and expedite the whole journey of expert analysis which needs to be performed. So I think from an AI, from the use of AI standpoint, kudos to that. The efficiency and how it's drastically reduced the timing of delivery, because usually experts get involved at the very last stage of a commercial dispute life cycle, and we are sort of flooded with a lot of information and data with very limited time. So that's where AI has produced very, very significant results. bringing a lot of accuracy and a lot of reliability also in the results that experts have produced in front of, let's say, either tribunals or the courts of law. Another area where AI has actually benefited experts a lot without adding too much threat is the overall drafting and structuring of the expert reports. I have to confess, again, I say that on behalf of the entire experts community, that I think when it comes to drafting, nobody can beat the lawyers. And we're actually very, very envious as professionals of lawyers, because I think no matter what we do, I don't think in our entire professional lifetimes we are able to draft as much. So in that sense, I have to say that AI has been a significant complementary tool to experts in commercial disputes, in helping draft much more sharper and very razor edge sort of reports. That obviously stands to benefit, because the way an expert opinion, and especially experts tend to come from very technical fields, they are very, very vulnerable to using extremely complex technical jargons, which at times gets extremely difficult to communicate to the recipient or to the beneficiary of the reports, which obviously are the tribunals, or let's say the mediators, or the judges. So that's one very straight cut advantage that we have seen. But we have to say that we thought that it is just we as experts who've been grappling with the threat of hallucination that we've experienced in AI, and it's actually very dangerous, because the moment you plant AI and you do not supervise, it tends to hallucinate, it tends to bring in certain technical analysis which you from your own days of professional studies or your MBAs would not have learned. I mean, it brings about theories and methodologies which makes you believe that either you're ignorant, and that's the kind of sense which has come about from experts. It's actually given a lot of comfort. Since morning I've been hearing that almost everybody has been coming out and talking about the hallucination aspect of AI. And I do understand that if the AI tools which are getting used are algorithm driven, then they are meant to be very sort of risk free or very contained in that fashion. But in our experience, wherever AI has entered into analysis of both documents and figures, or let's say it's even gone to draft reports, we've had several instances where before submissions, experts have sort of reported to say that, look, the AI was actually drafting the very raw opinion that the expert formed, and it just ended up publishing something very different. I mean, it was really not the opinion of the expert. So I think that is a threat which obviously cannot go without supervision. Another area where experts tend to have come forward to say where AI has been significantly helpful is in identifying, testing, and rebutting opposing expert evidence. So that is where it's brought about a lot of sophistication in terms of how quickly one can do the stress test assumptions in the opposing expert models, run counterfactual or sensitivity analysis, etc., etc. Another very, very critical element which we are now facing in use of AI is not that whether AI is aiding experts or not, but AI has itself emerged as a subject of expert evidence. So that is actually been very, very interesting, because we were, informally, some of us as the expert community were sitting together, and we were realizing that the kind of client issues that are coming to us to provide our technical opinions have been where clients are into commercial disputes, which are driven by underlying deep fake or manipulated audio video evidences, where the algorithm is set out, have been challenged, etc., etc. So while AI is an aid, but it's very also interesting that AI has itself emerged as a subject of contention in commercial disputes. Lastly, it's very important to understand that whilst AI can be an aid, but AI itself cannot be the expert. So it cannot emerge as an author. As a responsible community of experts, we completely realize that ultimately the owner's accountability, responsibility, and the ownership of the professional opinion has to lie with the expert. And in that whole journey of using AI, that responsibility certainly cannot transfer to AI. And I think with that element of cautiousness, the expert community continues to be heavily dependent on both AI and the other technology tools. But there's also a very collective acknowledgement on how we have to be a very responsible user of AI, so that the opinion, the evidence, the expert evidence which experts are today producing in commercial disputes are both reliable, accurate, and they end up being watertight evidences. So with that, given the scarcity of time we have, I take a pause, and so back to you.
So with this session comes to a close. I would like to make just two observations. I mean, I have been through the earlier sessions also. So what I can safely say at the moment is that the mood is that of skepticism with the possibility of change of mood. One observation I would like to make that so far as India is concerned, the lawyers are perhaps far ahead in use of AI than the judges. Thank you so much. Thank you all. The podium is open for the valedictory session.
That brings us to the end of our program, and the last session just before we end is the valedictory session. It will have a closing remarks session also, and some closing remarks also. So for that, could I please invite on the dais Honorable Ms. Justice Meena Bansal Krishna, Judge, Delhi High Court; Honorable Mr. Justice D.K. Singh, Judge, Karnataka High Court and President, Arbitration and Conciliation Center, Bengaluru; and Ms. Mamta Tiwari, Advocate and Secretary General, UIA India Chapter. Thank you. Thank you, Swati. I know it's been a long day, and this is the last session, and we are the last thought. So without much ado and wasting time, may I call upon Honorable Justice Meena Bansal Krishna to please give her valedictory address.
Good evening, Honorable Mr. Justice Upadhyay, Chief Justice, Delhi High Court, Honorable Judges of Bangalore High Court, of Delhi High Court, and all the members present here. It has been a fulfilling day, I would say. There has been discussions on areas about which we were aware to some extent, and on many aspects which were revealing. The valedictory assumes importance, especially because it is a summing up of what has happened in the entire day. While initially we thought that AI has come in only in recent times, but it was revealing and informative to be told that it came way back in its own form in 20s and 30s when aeroplanes were invented, and it is the AI technology in its own way which got introduced. The second was when the computers got introduced. We have been struggling And as was pointed out, that with each innovation, there was a challenge, but we have all accepted it. It is only recently when AI has emerged in its present form, we initially only felt the advantages and the strengths of AI. Essentially, AI based on algorithms doesn't pose as much as a challenge. In fact, it has always been supportive, an important assisting tool to all of us. The problems which have emerged recently is from LLM, the generative AI, which has started thinking on the basis of the data that is being fed in the machines, and that it has started doing its own innovative thinking. It is so smart, it is so effective, it is so articulate that many a times when the outcomes given by generative AI are presented before us, we tend to accept them all as the best solutions and the most correct interpretation. We essentially forget that these solutions or the advice or the recommendations come from the data, which is essentially foreign to our Indian culture. It is based on the data provided by the world, and therefore the solutions which may look extremely promising may not be so. They may not be suited to our Indian conditions. There was a very interesting example given by Mr. Parag Tripathi when he said that for hosting a wine party, it just put a message to the AI to ask which brand of wine would be most suited for the party. The answers came, but the next question was revealing. When it said that I'm giving this answer on the basis of repeat inputs that I have received. It was not catered or curated for the group that wanted to have a party, but it was more curated on generally how people have been responding. There are the challenges of accepting everything. It can maybe help us in forming an opinion, but to say that every solution being given is correct is where the problem lies. And therefore, important facts therefore got highlighted in the first session. Another takeaway which I can say is that it is not a time. It is a moment which has come to stay. We all accept AI in our day-to-day lives. The problem is not, the question is not of putting a handbrake, but it is to provide the guardrails. It is the guardrails which are required to be drawn so that it can be contained, controlled, and can be made to work for the object for which we are intending to use it. The second aspect which I could gather and which I would like to highlight is its use in contracts and in negotiated and as a negotiating assistant. When we talk of simple contracts of 2-page, 3-page, maybe AI may not be so useful, even though it may still give us the clauses which must generally be incorporated. But when we are dealing with large contracts, which involves hundreds and thousands of pages, as had been pointed out in the last session, it helps to collate, to organize. What was taking hundreds of days can be done in a limited time of 5 to 10 minutes. The biggest advantage is that when we are going through hundreds of pages, our mind may miss out certain crucial aspects. This is where the machine helps us. It identifies, it recognizes, and picks up all the relevant clauses. It may give us solutions, but the difficulty again is that it gives solutions on its own understanding of the clauses. But we may miss out on certain important aspects which are unique to the group, to the parties who are negotiating. And that is where we may go wrong in blindly accepting. So while I think the conclusion or the conclusion of in all the sessions was, it is a tool which is extremely effective. It can reduce in the times phenomenally in processing, in helping us in collating, in drafting, but definitely it cannot be the decision-making tool for us. It may look, and there was a concern which was voiced that over a period of time, maybe because of paucity of time, or lethargy, or dependency, we may start accepting the solutions being offered without checking, without verification, which is where the problem is. So the lethargy and the inefficiency, quote unquote, that it may induce is what is required to be addressed. Here, another aspect which got highlighted was mono conversations. While we always went back to our families, in the joint families, for having a meaningful conversation, which had relevancy to the values and the culture of that family, we went to nuclear families. Nuclear families where the focus or the interest got confined to the immediate family members. But the problem came when we got into the mono family, where ChatGPT has become our true friend. It is funny, but I can't resist from saying that we were traveling once in the train, and I saw my sister-in-law in the middle of the night talking to somebody on ChatGPT. And my question was, what are you doing in the middle of the night? She said, my daughter got angry. I was talking to her in US. She's got upset. I'm talking to ChatGPT to find out the solutions, how to make her happy. So that is the kind of dependency we are developing on the machines, rather than working on a human element and keeping it as an assistant, as a processing machine, and not as a decision-making authority. In the end, I would just like to highlight, there was something which has been said in all the sessions, and that is decision-making in judiciary. Now, there is also much talk that it predicts the outcomes. That can be very dangerous, because a litigant who gets a prediction on AI comes to the court with a mindset that this is how my case would be decided. If it doesn't come out that way, it immediately raises a question mark in his mind. And that is where, according to me, these predictive decisions can be dangerous for the credibility of judiciary. It can weigh heavily on the judges while deciding the cases, and this is where education and training is extremely important. A very important aspect was highlighted, that every litigant or every stakeholder relies heavily on AI. They immediately, whatever be the problem, it is the information taken through AI. Again, there is a problem, because the solutions are dependent on the prompts and the expert prompts that are put to get the answers. If the prompts are incorrect, or they are not in tandem with what the other person or the machine thinks, the solutions can be very, very erratic, creating a huge problem for the entire system. As has been said, another very important aspect which got highlighted was dispute prevention. Now the question is, how does it get prevented? Obviously, if we are able to plug all the aspects, all the loopholes, maybe through AI, there can be prevention. If there is a poorly drafted contract or certain aspects are missed out, obviously they become the potential for the dispute in future. If taken care of, I am sure they can prevent the disputes in future. In the end, its importance and significance in ADR has been highlighted. It has been the two aspects which are very, very significant and help us a lot in this ADR, the appropriate dispute resolution mechanism, as we like to call it, is the kind of questions that are put. The questions have to be right. You put a wrong question, it can demolish your entire mediation process. The second was in generating the options. If there are many options which get generated, it is an assistance to the mediator to work around them and to make the parties come to a solution. In the end, I would just say it is a technology which has come to us. It is unanimously agreed. It cannot be thrown out. We all must adopt it, except with a rider that we must be careful to the extent we depend upon it. Thank you. Thank you very much.
Thank you, Justice Bansal Krishna. Could I request Mr. Justice D.K. Singh to please give his keynote address?
Honorable Chief Justice Upadhyay, Honorable Justice Jayant Banerjee, Justice Suraj Govindraj, Justice Kash Kumar, Justice Harishankar, Justice Mamji, Mr. A.K. Ganguly, Senior Advocate, Mamta Tiwari, the Secretary of UIA, and other thin presence of the audience. The last speaker is like the last class before long vacation. So I will not take a very long time to conclude. This is the formality which most of I have to accomplish. Whatever was to be said, it has been said in several sessions. And my sister judge has further, cemented with all the thoughts. But nevertheless, I will say something, and thereafter I will request Mamta Tiwari to give formal vote of thanks. So it has been my privilege to participate in today's seminar. We stand at a critical juncture where technology and justice converge, are trying to converge. All of us gathered here today under one roof has explored both sides of question how AI is changing the world and whether it can bolster and endanger our legal system and jurisprudence. As US Chief Justice John Roberts had once observed, we are not about to become obsolete, but we are equally confident that technology's changes will continue to transform the work. AI does nothing. It doesn't improve your knowledge. It improves your efficiency. If you take it that way, that it improves your efficiency in justice delivery system, it is a very, very useful tool. Over the past sessions today, we have encountered several concrete examples that have been both illuminating and instructive. These have not only demonstrated how artificial intelligence is already being integrated into various facets of legal system, but have also helped us better appreciate its real world implication. AI is promised for justice and efficiency in several ways. All we know that in India, justice system suffers from an enormous backlog, over 5 crores pending cases across the country. By many accounts, that burden represents the greatest hindrance to timely justice. In this very context, AI offers powerful tools. One, in case management and research, AI-driven portals can accelerate overflow by automating the routine work. For example, the Supreme Court has developed in-house systems like SUPAS and SUVAS to extract relevant passages and translate judgments. These tools can summarize documents, translate judgments into Indian language, and assist judges in legal research. Access to justice, that is another aspect of the AI system. In online dispute resolution, AI can demonstrate legal help. Platforms like SAMA and Presolo 360 already use machine learning to try thousands of small claims in weeks rather than years. As Niti Aayog ODR policy notes, AI can help parties avoid disputes by flagging risky context terms early, facilitate early mediation, and resolve cases online. Remarkably, SAMA settled 10,000 disputes in 6 months using AI assistance case machines, showing how low-cost tech can handle high-volume cases. Efficiency in court is another aspect where AI is extremely useful. AI tools can aid judges by reviewing evidence and transcripts. Technology like speech-to-text transcription, for example, which is already being used by the Supreme Court. For live courtroom and AI checkers for e-filing errors, speed up proceedings and reduce clerical errors. The goal is not to replace judges, but to free them from the routine work, so they can focus on judgment and reasoning. Echoing this, Justice Vikramnath, who was the speaker before one session, he said, AI must never replace the trained mind of lawyer or the disciplined judgment of a judge. Likewise, Justice Satish Sharma has reminded us, no algorithm can govern a human soul, stressing that compassion and conscience cannot automate it. Our discussion today underscored this promise by making dispute resolution faster, cheaper, and more accessible. AI aligns with the core aim of law to make justice available to all. As one speaker noted, integrated AI over ODR could make informal justice our first resort for everyday issues, reserving courts for only the most complex matters. It is encouraging to see our laws evolving in steps with technology. Internationally, India's approach is informed by global standards. We have taken cues from AI Act of European Union, Canada's transparency mandates, and UK ethical guidelines. UNESCO's December 2025 guidelines for AI in courts and wait. They advocate transparency, accountability, human rights protection, and all other familiar principles which have been adopted by Government of India as well. We too should consider such multilateral principles. After all, justice is one democracy, can set examples for others. The court's white paper, Supreme Court white papers of 2025 recognizes India's opportunity to lead by example, reminding us that India's judiciary is uniquely positioned to influence global standards on responsible AI governance. Responsibility and call for action. This is the last topic which I conclude my speech. What emerges ahead is a clear roadmap for our legal fraternity and policymakers. Our duty is to ensure AI serves ends up to justice, not define them. Concretely, This means capacity building. Judges and court staff need training in technology. The white paper suggests regular AI workshop and capacity building programs. Likewise, legal education should include AI literacy so upcoming lawyers understand algorithmic tools and their pitfalls. Ethics committee and oversight. Courts should establish AI ethics committees as proposed in the Supreme Court's roadmap to vet new tools, monitor their use. These bodies can set standards for fairness and handle any dispute about AI use. In-house secure tools, we should prefer domestic code-controlled solutions over external black boxes. India's development of sovereign AI system like LEGRA, Supreme Court's generative research assistance, is exemplary. Similar in-house tools can be expanded for case management and e-filing. If we rely on in-house systems, we keep data local and controlled storage. Updated procedures. The Civil Procedure Code and court rules may need amendments to explicitly allow AI-assisted filing and ODR processes. Government bodies and bar association can work together to process such reforms, ensuring our laws keep pace with technology. Public trust and dialogue, for which we must maintain public confidence, keeping proceedings transparent and explaining AI use will help. Outreach through bar councils, legal literacy programs, and media can demystify AI. If litigants know that AI is a tool under court control, their trust in justice will grow. In short, all stakeholders must collaborate. The UIA itself is a platform for such global exchange. Being a part of the bar and the bench, let us continue this dialogue beyond today. By sharing experiences, we can develop best practices that protect local values while embracing global innovations. The discussions that we all have been part of today have been enlightening and sobering in equal measure. We have seen the promise of AI to reduce dependency, improve efficiency, and broaden access to justice alongside its risk to privacy, equality, and due process. Our task as custodian of law is to balance these forces. Let us remember that technology, however advanced, is a mean, not an end. The Supreme Court reminds us emphatically that AI will serve the ends of justice, not define them. This should be our guiding mantra. We carry responsibility of ensuring that whatever tools come, the human values and spirit of our constitutions remain intact. Thank you.
Thank you, sir. Before I give the vote of thanks, we had something called the Hackathon for Justice, and Shreyas Jaisimha has some concluding remarks in respect of that. Could you, Shreyas, come here and address?
This is really the relay race where the intergenerational baton is being passed on, and the 20-year-olds had outstanding ideas. Prior to this conference, yesterday we had a hackathon inviting technologists, designers, lawyers to gather and collaborate, and we had the head of Sarvam AI, that is India's indigenous AI platform, as one of the judges. We had a person from the legal technology space and also another lawyer as one of the judges. And the three winners are here. I'd quickly ask you to please come up on board. It was astonishing to see them create solutions within hours. The solutions that we've been living with for years, the promise and hope of the youth is that the most difficult problems can be addressed creatively, collaboratively, and successfully. So first, I'd like to call on, this is the team from National Law School who won. Please come up. They created, within 24 hours, a platform, this way, just describe who is your designated speaker? Just describe quickly what you have.
So we created a criminal management platform that essentially streamlines the communication between public prosecutors and investigating officers. This is aimed at making sure that everybody in the investigation process is actually meeting the statutory deadlines, as well as trying to better the quality of evidence that is collected and submitted to the courts. Thank you.
This has the promise to accept on your behalf one plant. I would request Justice D.K. Singh to please hand over a memento to the winning team. Thank you. Meanwhile, I'll call upon the next team, which is looking at domestic violence. India is a country where the same phone is used by many members of the family, including the perpetrator of violence in a home. So how then do you use the same device to protect the victim in the same house? It's a complex problem, social problem, technological problem, and they have a solution for it. And this was again a product of the hackathon. Please.
Thank you, sir. I'm from UIA, an NGO, so we work in the access to justice space through creating legal information across several media platforms and through Samvidhan Fellowship, where 40 district lawyers are practicing in Karnataka, Bihar and Maharashtra, catering to several audiences. But specifically, like sir was saying, several of our beneficiaries have been survivors of domestic violence, and they still face severe challenges in terms of seeking help and protection. So our app called Ask Nyaya, which is in addition to our manual helpline that exists, envisages a discrete app that can trigger conversation just with a hidden code, and then it would also identify specific situations of violence. The risk assessment happens, and it could probably give out all the help centers, helpline available. Many people struggle to see if the jurisdiction exists or not, is the helpline functioning or not, but this one app could give the list of all services that are available at a stretch for the users. Thank you for this opportunity.
Please accept from Justice Bansal Krishna, please. Accept a memento, please. And finally, we had one non-lawyer who is here amongst us. He has no legal background. He spoke to a few lawyers. He heard about the hackathon. He came as a solo person, and he asked lawyers what is the most pressing problem. And the pressing problem he heard of was that they don't have access to the most updated acts. You know, the bare acts get updated in a delayed manner. He's attempted a solution in 25 minutes.
Yeah, so actually there's a partner who from Trilingual named Jaydeep Reddy. Yeah, okay. Anyway, so I built a pipeline that essentially takes the Gazette notifications and creates an as amended act directly from it. So that it can show you a timeline from, like, if there were 4 amendments across the years, it will show you exactly what was amended and when, and give you the final amended act. And the pipeline takes about a few minutes to create for a single act.
So we are seeing only the tip of the iceberg, and we want to end on a positive note. Please accept a quick memento from Ms. Mamta Tiwari. And so we wanted to end on a positive note, saying that we've heard many dangers, but the promise of the application of AI and technology and collaboration is real. And the winners, I could not read out their names earlier, so they were from Nyaya Assist, Rakshit Dwaram, Vignesh, Vibhav, Dharmakirti and Vibhav. Just now we heard from Rohan Shiralkar of Clausio, and we heard also from Ask Nyaya, Aditi Navaram and Ruchika Kulkarni. Congratulations.
We now come to the last bit, vote of thanks. Let me start by thanking the Honorable Chief Justice of India, Justice Surya, to have agreed to come and inaugurate the seminar here in Bengaluru, which, as everybody agreed, was the perfect venue to have hosted this seminar. We are also grateful to Honorable Justice Vibhu BAKHRU for having given his unflinching support to the seminar. We are grateful to, most importantly, Honorable Justice Jayan Banerjee, the Karnataka Judicial Academy, Ms. Radha, for having given her support all through. We are really grateful, sir. Without your support, this would not have been possible.
We are grateful to Honorable Justice T.K. Singh, the Arbitration and Conciliation Center, Bengaluru, for having supported us in the seminar, to National Law School of India University, Bengaluru, for having partnered with us. Thank you very much, NLSIU. We are grateful to Honorable Justice D.K. Upadhyay for having come down from Delhi. Grateful, my lords, for your presence here and for having sat through when the attendance is very thin. To Honorable Justice Suraj Govindraj, grateful, sir, for your attendance and for your encouragement all through the seminar. We are grateful to Honorable Justice Suraj Govindraj and Honorable Justice Krishna Kumar for having been here. We are also deeply, deeply obliged that Honorable Justice Anup Jairam Bhambani and Justice Harish Vaidyanathan Shankar, Honorable Justice Tejas Karya could make it. We are grateful to Honorable Justice Jal Banerjee for having sat through and having given us the wholehearted support. Lastly, my gratitude goes to our sponsors, KPMG, LIC, Shardul Amarchand Mangaldas, and Shivdas partners who contributed and helped us immensely in the seminar. Thank you, and I'm very grateful for your attendance here today. Tea is outside. Can I request the delegates and the dignitaries to please join us for tea? Thank you.